It is a matter of great honor for me to present before you all the brief introduction of our today's resource person, Professor Dr. Chidananda Reddy S. Patil. Sir graduated from University of Mysore in 1983. Sir moved over to Dharwad to pursue his studies in law at University College of Law. Sir completed his LLB in 1986 and obtained master's degree in law from University of Mysore in 1988, specializing in constitutional law. Sir secured first class and first rank at LLM, for which he was awarded 2 gold medals and a cash award by the University of Mysore. In addition, the government of Karnataka has awarded Sir with a cash prize for securing first rank in LLM. Sir holds a doctorate in law from Karnataka University, Dharwad. Sir has taught law for over 3 decades at JSS Law College, Mysore, Hurkadli Ajja Law College, Dharwad, KLE's Law College, Bengaluru, University College of Law, Dharwad, and KSLU's Law College, Hubballi. And also, Sir has discharged responsibilities as Dean, member of the Syndicate and Academic Council of KSLU, and Director of KSLU's Law School for 7 years. Sir has authored 1 book, edited 4 books, and more than 85 articles in law journals. Sir is one of the experts to submit a research paper to the Committee of Reforms of Criminal Justice System, of which Honorable Dr. Justice V.S. Malimat was the chairperson. Sir has drafted many legislations for the government of Karnataka, including the Karnataka State Human Rights Codes Rules 2006. Sir has received a commendation for his work in the field of human rights in 2010. Sir was a member of Expert Committee for Establishment of Karnataka Rural Development and Panchayat Raj University. Sir envises a lot of interest in curricular, co-curricular, and extracurricular activities and has actively involved in legal aid and legal literacy activities for more than 25 years. I once again, on behalf of Karnataka Judicial Academy and all the attendees present here, welcome Sir to this session. I request Sir to address the officers on overview and philosophy behind introducing major reforms in all criminal laws, relevancy of new crimes introduced as means to address contemporary challenges. Over to you, Sir. Thank you.
Good morning, everyone. It is so nice to be here amidst the honorable judges and the learned prosecutors. I see some very familiar judges and prosecutors who are here, with whom I had the privilege of working as a faculty member in the law school and earlier in University Law College. And I really had a very pleasurable experience, especially when we went out in connection with legal aid and legal literacy programs. And I am convinced that it is you, the people, who are operationalizing the law so that it will come in contact with the individuals who are deprived, and you are the agents of justice, both prosecutors and judges, carrying that onerous burden on your shoulders. Honorable Justice Shivraj Patil, sir, he never uses the word lower judiciary. he says foundation courts. For many a number of people, these are the institutions which are the final courts of appeal. There is no appeal in many a number of cases, and whatever that is done there is the final version. And that brings a lot of responsibility on all of you. Now, you have gone through this video that was played. We are entering a new regime of a sort of changed jurisprudence or shifted legal system to some extent. Certain of the provisions remain same, certain changes are there, and you are the people who are to implement these things. And how you are going to take this through. Everything is new. When the Constitution was adopted, in the first case, A.K. Gopalan, Nambiar was to argue that case. When Nambiar is to argue A.K. Gopalan's case, there is no plethora of judgments of the Supreme Court which he can cite, and on the basis of these judgments he will argue. There is nothing. He had to go there with the bare text of the Constitution in hand and advance his arguments. Same was the case when Marbury versus Madison was argued in the American Supreme Court. We remember the judges, Justice Marshall, who delivered that judgment, but we forget the person who argued that case. See, these things happen. Now, new things have come, and maybe a series of guidelines will follow, directions will follow, interpretations will follow, and a new type of jurisprudence will be built upon certain of these provisions which we find to be at the loose end right now when we read the bare text of the new provisions. When we approach legal systems, we have to appreciate the foundations on which the legal systems are built upon. We are not a continental system. We are Commonwealth, Anglo-Saxon. The system that we have adopted is adversarial. We are not inquisitorial system. We are adversarial system. And when we look into the rules of procedure and evidence of the inquisitorial systems and adversarial systems, you find a drastic difference. The burden of proof aspects will totally change. In our system, when we speak of a controlling constitution, which we have adopted at the end of all that exercise over a period of 2 years and 11 months, wherein huge personalities, doyens of law were in the Constituent Assembly, and ultimately they adopted the Constitution. On November 1948, when the draft of the Constitution was introduced in the Constituent Assembly, Dr. B.R. Ambedkar has made a speech there. And at the concluding session of the Constituent Assembly, he has made another speech. These two speeches, whether we read the whole of the Constituent Assembly debates or not, we have to read these two speeches to understand the core or the essence of the Constitution. It is not an ordinary document. Constitution is not an ordinary document. When a constitution is made, what people are doing is they are creating a document in which they will infuse their sovereign power, and this document which they have created will control them, and it will also control all the institutions which are creatures of the Constitution. That is a controlling constitution which structurizes the exercise of power by any organ of the state. Legislature, executive, judiciary, all of them are controlled by the structure that is there in the Constitution. So power can flow only in the permitted channels as permitted under the Constitution, nothing else. That is the bold experiment on the part of the people of any system to create a Constitution. And the fact that this Constitution has survived or answered or catered to the needs of people of India over a period of 7 decades is the proof of the fact that this is a great Constitution. Of curiosity, you just Google and check in which year the Constitution of Sri Lanka was adopted, China was adopted, Bangladesh was adopted, Pakistan. Therein the constitutions fall like that. But this is a different type of constitution, huge constitution. Constitution in the making, H.R. Khanna, you have to read such a wonderful compilation of lectures by Hansraj Khanna, the Justice Khanna, who is of the fame of that dissent he wrote in ADM Jabalpur versus Shivkant Shukla, for which the whole world appreciated his judgment. At the cost of losing the opportunities, he was bold enough to write that. B.N. Rao, making of the Indian Constitution, Shiva Rao papers, and the most outstanding, Granville Austin, Indian Constitution, the cornerstone of a nation. And he is an historian who has written about the Constitution, and he survived to see the working of the Constitution for 50 years. After seeing the working of the Constitution for 50 years, he has written another book, Working of a Democratic Constitution. That is the situation. When Sir B.N. Rao, please read Sudesh Pai, Legends of Law, such a wonderful book, and such a ready-made short notes on great personalities in 10-12 pages. He has done total justice to each of the personalities. Therein he writes about B.N. Rao. Sir B.N. Rao was invited to be part of the Constituent Assembly. At the same time, he was invited to occupy the position of a judge by the British government. And the type of reply Sir B.N. Rao writes to the British government, look, sometimes people are at crossroads and I am at crossroads now. I have an offer from my countrymen. They think that I know something about the constitution making. And you have given me this offer. Thank you very much. I go with my countrymen. So he joined the Constituent Assembly. And as part of that, he had to travel to different places and meet people. And one of the eminent personalities he met was Chief Justice Marshall, America. And Justice Marshall advised him not to use this expression due process in the Constitution of India. He said, you are a nascent democracy, you have come into existence just now. And due process is a clause which was abused during the New Deal era in America. We have suffered a lot under this provision, and later again we could recover by interpreting due process in the right perspective. So under this expression due process, their system has suffered for more than 50 years. And you are a new country, don't use this expression due process because it is a double-edged sword. It cuts on either side. So that expression was avoided. Instead, we used procedure established by law. If a person's life or liberty is to be deprived, it can be done only according to the procedure established by law, procedure as laid down through a legislation, and later through interpretation. The Honorable Supreme Court has said that it is not any procedure, it should be a just, fair, and reasonable procedure. When we say procedure established by law, it is not any procedure. If there is a law which has provided for some procedure which is not in conformity with the due process requirements, that will be struck down to be unconstitutional for violating Article 21 by the Supreme Court. That is the jurisprudence that is built. Process that is due, process that is just, fair, and reasonable. Only according to this, a person's liberty can be deprived. Liberty is of utmost value There is no confusion about it. Right now, when I was speaking with our Honorable Director of Judicial Academy, I was mentioning, maybe as teachers we are failing because we are not inculcating the knowledge of the basic things when these children come to our schools to study law. And over a period of time, once you get into the profession, an advocate should be a perennial reader, perennial student. A teacher should be a perennial student. A judge should be a perennial student. Everyone, whoever who is a professional, he should be, who is a professional. The basic necessary preliminary input to be a professional is intellectual in character. Unless I have that intellectual ability, unless I have acquired a bastion of scholarship, I cannot claim to be a professional. That tag may be there, that he is so and so, but I should live up to that tag. So, continuous pursuit of knowledge is very, very important for the basic concepts. Liberty. Liberty on one hand, restraint on the other hand. Learned hand is a great author. As a student of LLB, I felt it is a sort of fanciful quote. ಯಾರೋ ಏನೋ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಬರೆದ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ತಮಾಷೆಗೆ ಲರ್ನೆಡ್ ಹ್ಯಾಂಡ್ ಅಂತ ಬರೆದಿರಬೇಕು ಅಂತ LLBಯಲ್ಲಿ ನನಗೆ ಅನಿಸಿದ್ದು. ಆ್ಯಂಡ್ ವೆನ್ ಐ ಕಂಪ್ಲೀಟೆಡ್ ಮೈ LLB, almost at the verge of completion of LLB, I stumbled upon this book, Liberty by Learned Hand. Then I came to know that learned hand is a person. It is not a hand, it is a person, and really learned person on liberty by Learned Hand, a small book. Such a wonderful book. And one of the often quoted statements of Learned Hand is, liberty should live in the hearts of men and women. If it lives there, no constitution, no law, no court is necessary to protect it. If it dies there, no constitution, no law, no court can protect it. Swami Vivekananda, small caption. Nothing can confer freedom on you unless you have it not already. Nothing can confer freedom on you unless you have it not already. And I stumbled upon a Sarvagna Vachana in this regard. Tantri Vadyavalisu, string instrument is good. Mantriya Kelelesu, friendship of a minister is good. Yantra Vahakana Dayalesu, we are all at his mercy. He should be careful. As long as he is careful, we are safe in that way. Yantra Vahakana Dayalesu, Jagadi Swatantra Velesu Sarvagna. So, he also attaches, and Kautilya, it is not worth living in a country wherein there is no freedom. That is the value of freedom. That is the value of liberty. A dog was sitting there. It came in WhatsApp as others are there. I am also a student of WhatsApp University. I want to learn so many things from that university. That was a picture, one dog with lot of gold ornaments. All sorts of ornaments he has put. A very dignified, well-decorated dog, rich dog. And in front of that there is a highly famine-struck, bony, skinny dog. This bony dog is asking this rich dog, "Oh, you are from which place?" Then this dog answers, "I am from Pakistan." "How is life there?" "Hey, can't you see? All this gold. I eat only chicken biryani, boneless, with butter, whatever. Everything is fantastic there." Then this fellow asks, "Hey, why did you come to India?" Then the dog answers, "Look, I am a dog. I am not allowed to bark in Pakistan. In India, you have freedom. A dog can live like a dog. That is the liberty that is given to even dogs in this country. So it is not worth living for a dog without barking to live in, cross the border, because there is liberty. It's satiric. Liberty is very, very precious, and liberty is very dangerous. All of us, by experience, we know. As long as there is a senior judge to you, he will ask him what to do, what not to do, and all that. And now you have become the senior. You have to take decision. Somebody is coming, who has to go to airport, how many bouquets, whether there should be ladies accompanying, when the lady is coming. So many decisions you have to take. Earlier, there was an elderly person who was taking decision, I was implementing. Now I am decision making. As long as he was sitting there, I was feeling I should sit in that chair. Now that I am sitting in that chair, I feel this was better than that. Because there is a lot of hassles are there sitting in that chair. So you got that freedom. Freedom comes with lot of responsibility. And there is every probability that freedom will be abused. And all those people will come before you, whoever who abuses the freedom. There should be restrictions on freedom, limitations on freedom. Why limitations? Limitation on freedom, limitation on liberty is in the interest of liberty itself. It is not against liberty, it is in the interest of liberty that there should be limitations on liberty. Harold Lasky, Grammar of Politics, one of the basic books to be read by people who are interested in constitutional law. Equal liberty of others is a limitation on my liberty. My liberty is circumscribed by the equal liberty of all of you, other people. And my liberty is a limitation on your liberty. That is the relationship that is there between the liberty and limitations. But limitations should not be arbitrary. We have to bear one thing in mind, all these human rights, fundamental rights are available against the state. They are available against the state. Against private individuals, you have private law remedy. This is public law. Public law remedy is available against the state, and state is a mighty power holder. As Justice Krishna Iyer says, he is a common man. Common man cannot match the state power. And he cannot stand up to the state. And state power, it is so big that sometimes it may trample upon the liberty of the individuals. That's why the power is to be controlled in the interest of liberty, because this person cannot defend himself. So when we speak of due process checks the arbitrary limitations on liberty. State will enact laws, restrict the liberty. If it is arbitrary, then you can question it, go to the court of law and get that formula tested as to whether it is constitutionally tenable. So how to restrict? When we speak of CRPC, we speak in terms of restricting the liberty of the individuals. When we speak of arrest, search, seizure, etc., we speak in terms of restricting the liberty. There should be an appropriate balance. What is necessary is allowed. At the same time, liberty is to be respected. So when we speak of traditional criminal law, it is a law of evidence, law of procedure. The evidence we do not call procedural law, we say it is adjectival law. CRPC is procedural law. These principles have come into existence as a result of state policy. State policy. See, when state is passing through different stages of life, there are various forces at play. If I criminalize certain of the activities, see, right now that debate is going on. If we are going to hold the people of the platform, Facebook, Meta, Instagram, whatever, for the content, they say we are a platform, anybody can come and post anything there. and you hold him responsible for whatever he has posted. And as a platform, you cannot hold me responsible for whatever he has posted. The government, what government does, government will pass take down orders. Say, this is there on your platform, take it down. So they will be taken down. About that also there are lot of controversies. What these people say, if you are going to hold us responsible for whatever that is posted on our platform, we will not operate in our country at all. We will go out of India. Can we do without Facebook, without WhatsApp, without X, Y, Z? And now courts have said 2 blue tick means it is communicated. Right? But that fellow, he says, I will withdraw from your country. There are economic factors, investment factors, convenience. So many things are there. Freedom of expression is there. All those things. So whenever things are done, it all depends upon the stage through which the society is passing through. Sometimes you have to give liberty. Industrial revolution. When industrial revolution is taking place, you cannot speak of strict liability. If you speak of strict liability, nobody will put an industry because he will not take any risk. If you are going to award huge compensation for the loss of life, limbs and other things, industrialization will not happen. That's why doctrine of common employment was brought in. Doctrine of common employment is straight against the welfare of the co-workers, but that was in operation. So policy changes. Minimum wages was held unconstitutional in America. Prescribing maximum number of hours of work was held to be unconstitutional in America during the New Deal. And all these laws were held to be constitutionally valid subsequently. After pursuing that, this laissez-faire business, absolute freedom of contract, that led to lot of misery, penury, exploitation of the lesser individuals economically. So that's why unrestricted freedom of contract exploited people. Capitalists exploited the workers, and they felt there should be some limitations on the liberty to carry on trade, business, and all this license Raj comes into existence, permits, and all those things. So, liberty is to be subjected to the authority of the state. Whenever liberty is for the ill of the society, liberty is to be regulated. So somebody had advised he has given a proposal to the government of Gujarat. You give me permission, I will see that best quality liquor will be available in your state. That was not accepted. That is a different thing. State policy is there. So liberty is to be subject to limitations. But state's authority to limit liberty is also limited by the Constitution, by the stipulations that are there in the Constitution. State has no unlimited. You have series of legislations which are struck down by the Supreme Court as unconstitutional, including the recent electoral bonds, ADR, Association for Democratic Rights, electoral bonds, struck down, arbitrary violation of 14. There is a criticism that Supreme Court has become a constituent assembly in continuous session. It has become a constituent assembly in continuous session. Because they go on reading the provisions. There are different readings. Reading up, reading down, we say Supreme Court has read down the provisions. Reading afresh, reading anew, suddenly they will say, now we have understood what is the meaning of this. As it happened in E.P. Rayappa. Equality, they said, now we have understood what is equality. New dimension of equality. It is against arbitrariness. So we follow the interpretations. There is a wonderful book written by Lawrence Tribe, Reading the Constitution is the title of the book. Lawrence Tribe. I read this book because there was a name underlined in the preliminary pages. And the name underlined was Barack Obama. So this author, Lawrence Tribe, thanks Barack Obama for going through the first draft and correcting that. Barack Obama, President of America, no? Huge person. So if Barack Obama has assisted this person, I should read this book. I read this book. The title of the book is Reading the Constitution. The first chapter, How Not to Read the Constitution. So beautiful, no? And in that one subheading, reading the Constitution should not be writing the Constitution. I tell you, sir, madam, we are so fortunate to live in this period of availability of information. See, everything is available. But the only thing is you should be available. If you are so busy, you will be missing things. Other day, somewhere when I was with a former judge, a huge personality, after lunch, this pan thing came. Then I said, sir, I do not eat pan. I said, hey, this is a remand case, they said. I did not, I am a teacher. No, sir, what is the meaning of that? No. After your death, when you go there, you will be sent back to eat pan and come again. You are understanding what I am saying? All these books are available. If you do not read, okay, so they are interpreting the Constitution. They are reading it anew. New dimensions will come into existence. So, whatever that is unconstitutional will be struck down. The power of the Parliament to make laws is limited by the Constitution. The power of the Parliament to amend the Constitution is also limited by the Constitution. Various doctrines are evolved by the Supreme Court over a period of time. So, what state does, it can do only that which is permitted under the Constitution. There is a concept, French concept known as administrative legality. For every action, there should be authorization in law. Without authorization in law, nothing can be done by the state. You may be power holder, but your power can be exercised only for permitted activities, nothing else. Otherwise, the concept of personal liability will come in. So, depending upon the requirement, state criminalizes certain of the activities. State criminalizes certain of the activities. There is a wonderful book which was prescribed for the studies of all of us, Outlines of Criminal Law by Kenny. In the first chapter, it is a very small chapter of 2-3 pages, the statement comes, crimes originate in the policy of the government of the moment. Crimes originate in the policy of the government of the state will decide what to criminalize, what to decriminalize. See, we have seen over a period of these years when we are in the field, we have seen that certain of the things which were crimes earlier got decriminalized. Foreign exchange has become foreign exchange management. Foreign exchange regulation is gone. Now foreign exchange management has come. Food adulteration went into Food Safety Standards Act. So that food adulteration act is repealed. So over a period, depending upon the stage through which the system is passing through, certain of the activities will get criminalized, certain of the activities will get decriminalized. So crimes originate in the policy of the government of the moment. Government will create crimes. It will abolish crimes also. And when we speak of due process, which is relevant for the administration of criminal justice. Due process is highly formal in nature. Rules are there. According to those rules, facts have to come on the table of the judge. Only through permitted channels of relevance of facts. If you are not a crafty advocate to bring that piece of evidence and prove its relevance, it will not come on the table of the judge. The same judgment tried in Gujarat before one judge, the judgment is different. When transferred to Maharashtra, tried before another judge, the result is different because it all depends upon the evidence that comes before the judge. There are rules according to which, see, there are certain of the systems in the world wherein in law of evidence they speak of excluded evidence. Except these excluded evidence, the rest is admissible. But here we are a different system, we speak of relevance. So according to the fixed rules, evidence has to come on the table of the judge and he will decide according to the set norms. Facts are to be established according to the rules. Justice Midhas, when he retired, in his farewell speech, he made a statement which became viral, and many of you have received it through your WhatsApp. Truth is known to both the parties. It is the judge who is on trial. People know. Justice Malimat used to say, best source of information is the accused. He is the person, he is the culprit, he knows. And we have kept the best source of information out. And we trample with, we try with, we grapple with so many other sources and try to establish truth. Quest for truth. That is printed in bold letters in Justice Malimat Committee report. Quest for truth shall be the sole aim of justice. If you can arrive at truth, whether it is civil litigation or a trial of an accused, if you can arrive at truth, justice is done. That is the beauty. The whole process is designed to enable the court to arrive at truth. So you have all these procedural safeguards because of due process requirement of. Yesterday there was a live interaction in one of the TV channels. The parent of NEET was talking to the anchor. He was very, very vehement. Something has gone wrong, no NEET examination and all these things. That fellow stood up and said, for a Atankawadi, if the courts can open in the midnight, why not for NEET? He is watching. All of you are under watch. What you are doing is being observed. That's why that component of integrity is very, very important. Bekku kannu muಚ್ಚಿ ಹಾಲು ಕುಡಿದ್ರೆ ಯಾರಿಗೂ ಗೊತ್ತಾಗೋದಿಲ್ಲ. See, even a common man watches. So, proof beyond reasonable doubt is the standard. And Criminal Justice Reforms Committee very seriously concerned whether we have to go with this standard or whether we have to change the equation. Can we go for preponderance of evidence instead of proof beyond reasonable doubt? Truth determination is one value. Protection of innocent is another value. You have that great slogan, everyone is presumed to be innocent till proved. See, nowadays on TV debate, everyone, he is only an accused, he will come out clean, I will come out clean. In 5 rupees that is available to wash clean. Right, he is an accused. In our system, an accused is innocent till proved guilty beyond. That's it. That is one principle. And another, the procedure is so designed based on this principle, let any number of culprits escape. Not even a single innocent should be convicted. When I went to Dharwad from Bangalore to that college, everywhere they had chewed pan and they had spat on every electric switch, they spit on that. Benches, they spit. Roof, they had such a wonderful art. I was discouraged to this, what I will do in this college. I said, something is to be done. And something is to be done very, very vehemently. Everyone is a gentleman in the presence of a policeman. So I felt I will play a policeman. So with a big lathi in hand, I started administration. And I was very, very vehement. And in one of the classes, one fellow, gentlemen, stand up. What is that you want? Nothing, sir. Then why you are an idiot? Scolded him left, right, and center. Then after the class, he came to my chamber. Sir, ಎಲ್ಲ ಜನರ ಎದುರಿಗೆ ಆ ಥರ ಬಾಯಿ ಬಂದಂಗೆ ಬೈದ್ಬಿಟ್ರಲ್ಲ ಸರ್, ನನ್ನ ಮರ್ಯಾದೆ ಹೋಯ್ತಂದು. ಬೈಯೋದೇ ಮರ್ಯಾದೆ ಹೋಗ್ಲಂತ ಹಂಗೆ ಅನಿಸಿತ್ತು ಅಂತಂದರೆ ನಾನು ಬೈದದ್ದು ಪರಿಣಾಮಕಾರಿಯಾಗಿದೆ. ನಾನು ಒಂದು ಭಾಳ ಸೂತ್ರ ಮಾಡಿದ್ದೀವಿ. ನಮ್ಮ ಮಕ್ಕಳೆಲ್ಲ ಕೂತಾರೆ ಇಲ್ಲಿ, ಪಾಠ ಎಲ್ಲ ಇಂಗ್ಲೀಷ್ನಾಗ ಹೇಳೋದು, ಬೈಯೋದೆಲ್ಲ ಕನ್ನಡದಾಗ. ಮತ್ತು ಅವ್ನು ಕನ್ಫ್ಯೂಸ್ ಆಗಿ ಹೊರಗೆ ಹೋಗಿ, ಸರ್ ಇವತ್ತು ನನ್ನ ಭಾಳ ಅಪ್ರಿಷಿಯೇಟ್ ಮಾಡಿದ್ರು ಕ್ಲಾಸ್ನಾಗ ಅಂತಂದೆಲ್ಲ ಹೇಳ್ಕೊಂಡು ಕನ್ಫ್ಯೂಷನ್ ಬೇಡ ಅಂತ. ಆವತ್ತಿನ ದಿನ ಅವನಿಗೆ ಏನೋ ಸ್ವಲ್ಪ ಕೆರೆತ ಕೈಗೆ, ಈ ಕೈ ಕೆರೆಯಕ್ಕೆ ಹಿಂಗೆ ಮಾಡ್ಯಾನ, ಅದು ನಾನು ಕೈ ನೋಡಿಬಿಟ್ಟಿನಿ ಅವನಿಗೆ, ಬೈಸ್ಕೊಂಬಿಟ್ಟ. He was a innocent victim. But as a teacher, I have to take that risk of scolding an innocent also. ಈ ಬೈಯೋದ್ರಾಗ ಬೇರೆ ಬೇರೆ ನಮ್ಮನ್ನು ಇರ್ತಾವೆ. ನಮ್ಮಲ್ಲಿ ಒಬ್ಬರು ಐ ಜಿ ರೇಗೌಡ್ರು ಅಂತ ಒಬ್ಬರು ಭಾಳ ದೊಡ್ಡ ವಕೀಲರಿದ್ದರು. ಅವ್ರು ಲಾಸ್ಟಿಗೆ ತಮಗೆ ತಾವು ಬೈಕೊಂಬಿಡ್ತಿದ್ರು. ಭಾರಿ ಎಫೆಕ್ಟಿವ್ ಮೆಥಡ್ ಆಫ್ ಓಕೆ. ಸೊ ನೌ ದಿ ಕ್ವಶನ್ ಈಸ್, as a system, can we run the risk of convicting an innocent? As a system, can we run the risk of convicting an innocent instead of having a procedure that will allow the real culprits to escape? What is the danger there? Benjamin Franklin: those willing to give up little liberty for little security deserve neither security nor liberty. Impossible. You cannot interrogate a dreaded terrorist Naxalite with agarbatti in hand, pleading and requesting to come out with facts. Take him for discoveries, whatever technical language you have. Human rights. Terrible, I tell you. It may be so nice to be a judge, a professor, and a prosecutor, not a police officer. They are under terrible pressure because all this legal system is watching them. They have to conform with so many requirements. At times, we should be in a position to give up liberty for security. We are safe, and we cannot understand how it is to get killed at the hands of a Naxalite or a terrorist. The child who has gone there, see, other day you saw, no? Toddlers are shot dead. Terrorists, see, that is, terrorists have no enemies. They kill innocent people. They want to create that fear psychosis in the society. If I have lost my relative, my son, daughter, brother, in the shootout, then only I will understand how a terrorist is to be handled. Otherwise, I am a champion of human rights. I say, biryani is to be given to a terrorist who is in the cell. Right? Stringent laws, sometimes there is a risk. When curfew is there, we have to switch off and stay back home because normalcy has to return. If everyone wants to exercise his freedom, normalcy will not come. So for that reason, this is a wonderful statement of Benjamin Franklin. And when these new types of crimes came into existence, there was a shift in the criminal jurisprudence. The old doctrines did not give answers to the changed situations. New crimes came into existence which have greater impact on the society. Socio-economic crimes, they have huge impact. And in the place, Vishwesvaraya Tower, wherein my office is there, every day, many women, children, they come there, they are filling some forms. Some banks are liquidated. They have to follow some procedures and they will get 1 lakh, something, whatever. So when a bank disappears, hard-earned money of all those people, when people play with this insider trading and manipulate with the share market, people's money is involved there. So these are very dangerous things that are there which require a change in the principles according to which these things are to be dealt with. Strict liability and absolute liability came in. Vicarious criminal liability. Otherwise, traditionally, we were taught that vicarious liability is not applicable to crimes. And then burden of proof shifted to the accused, presumption of guilt, deterrent punishments, mandatory minimum punishment, huge fines, and then confiscation of goods, denial of benefit of probation, quick trials, summary trials, constitution of special courts to deal with certain of the offences, making them cognizable, non-bailable, etc. And these principles have percolated into different statutes by now. As judges and prosecutors, you have read certain of the NDPS Act, illicit traffic in NDPS, dowry prohibition, prevention of atrocities, etc. These things are sprinkled over there. No, nothing wrong with that. At times, special situations require special equations. So on one side you have liberty, on the other side you have restraint, and the pendulum keeps swinging between liberty and... This is a wonderful statement of Jeremy Bentham, one of the great jurists. Every precaution which is not absolutely necessary for the protection of innocence affords a dangerous lurking place to crime. So procedural protection is necessary, but in the anxiety of providing such a fair procedure, don't provide a dangerous lurking place for crime. What maxims of procedure can be more dangerous than those which put justice in opposition to itself and which establish a kind of incompatibility between its duties? What you have to do? You have to respect this and you have to control this. How you will tread upon that delicate balance. This is one statement which is etched on the rotunda of Attorney General's office in America, which I like most. The United States, there is a spelling mistake that is to be corrected. The United States wins its case whenever justice is done to one of its citizens in the courts. So it is not the conviction rate that is important. It is the conviction of the culprits that is important. The real culprit should be punished. And that's why this is the statement. Every time justice is done, if an innocent is acquitted, a prosecutor should celebrate his victory in that case. He should not feel bad. The job of the prosecutor is to get a criminal convicted, not conviction at any cost. A defense counsel's job is not to get acquittal at any cost. The duty of both of them are to assist the court in administration of justice. Nothing beyond that. Otherwise, we will be failing in our responsibility. Liberty is to be protected, innocent is to be protected. Otherwise, there is what is known as judicial murders. Wrong person is convicted and executed. After that, the real criminal surfaces and he says, yeah, I remember that one I had done, this one I had done, this one. By then people are prosecuted, incarcerated, executed and all. But judge at that point of time, going by the evidence, it all depends upon who is the defense advocate, who is the prosecutor. See, in 1 month there were 2 death sentences given in Belgaum court, and I was told those who were accused of murder in prison, they stopped eating food in the prison, because this is the combination of the prosecutor and the judge that handed down 2 death sentences in 1 month. So those accused, they were scared to the bone. Okay, that's how. They are all agents of justice, not conviction at any cost. So like this, the equation will be changing, not to get disturbed. This is a pendulum. Depending upon the requirement, there should be recasting of the procedure, recasting of the definition of crime. New crimes will be created, and certain of the crimes which were hitherto crimes will be decriminalized. And after working this system for so many years, the government of India felt we will go for a change in the system overall. Tinker with that. Wherever. Robin Auld, Lord Robin Auld was in charge of criminal justice reforms in England. He came to India and met the people. Criminal Justice Reforms Committee was working here. And after interacting with Justice Malimat, he went back and wrote in England that when England is tinkering with the peripheries, India is taking leaping steps in justice reform, in criminal justice reforms. So each system responds to the requirement, and you have seen the clipping of Honorable Home Minister, the statement made when he introduced these bills in the Parliament. Nyaya Samhita. From Danda Samhita we are going to Nyaya Samhita. To do justice, not to punish people. They are playing a discrete combination of deterrent and reformative concepts when we speak of Nyaya Samhita. Nyaya is something bigger than justice. There is no equivalent in English for Nyaya. Justice, they say there are different types of justices, and maybe there is a concept known as restorative justice. And restorative justice is a thing which can come near to our concept of Nyaya. Otherwise, that is such a wonderful thing. So, Nyaya Samhita, the aim is not to punish, but to provide justice. Rate of conviction is to be enhanced. Conviction of whom? Criminals, not everyone. That is a thing to be bothered. The rate of acquittals, sometimes we have a lot of satiric equations, jokes about all these things. A public servant who wants to build a house will get himself trapped in some small offense, and he will be convicted, he will be suspended, and he will go to build the house. Enquiry is not completed within so many months, he will get his full salary. Full salary for what? For being suspended. So, no leave, no objection, nothing. One of the very crazy cases for an offense of taking 200 rupees bribe, there was conviction. It was confirmed by the High Court and by the Supreme Court also, of a police sub-inspector. Sometimes freak things may happen, but that's how justice should happen. That is not freak. That is correct. But it has become a sort of paradise. That is not to be done. Then use of technology, 0 FIRs within a timeline, it is to be transferred to the appropriate police station. Copy of the FIR is to be given. Arrest is to be documented, and there should be an officer in the court who will give the information to the relative of the arrested person, timeline for the purpose of completing the investigation, trial, and all that. And withdrawal of prosecution, sanction for prosecution, these two are the bottlenecks when high influential people who matter are involved. So about sanction for prosecution, there is a provision that the sanction is to be given. Otherwise, after 120 days, it will be presumed that the sanction is accorded. Lot of, while withdrawing the prosecution, there should be a say to the victim as to whether there should be withdrawal or not. All these benevolent provisions are there. Waiver of punishment, therein again victim is given some say. There was a law commission report that recommended overhauling of the two legislations. CRPC was done, but IPC was left. And government has time and again has said that these laws are colonial in nature. A reference to those colonial words, language is catalogued several times. IPC is amended sometimes. Supreme Court through interpretation has decriminalized certain of the activities, but it continued to be a relic of pre-independence British era. Outdated provisions, lot of them redundant, were to be removed and it was to be recast. That's what that is done in the new criminal justice system. When it comes to the point of Bharatiya Nyaya Shastra, there is streamlining of provisions relating to penalties, punishments. Earlier, this community service was not there. Now that is added. Some offences are made gender neutral, and some new crimes are added. Organized crimes, snatching, chain snatching, etc. Petty organized crimes, terrorist activities, separatist activities that affect unity and integrity of India. All these things have come into existence. And fines are suitably enhanced given the rupee value, but even now also it appears less given the gravity of the crime, and term of imprisonment also is enhanced. And Bharatiya Nagarika Suraksha Samhita, when we go through the statement of objects and reasons, it is to provide a fair and efficient justice system. That is one of the essential requirements of good governance. Delay, we have talked much about delay, and delay is attributed. See, delay is inbuilt in the procedure that we have adopted. Nobody is to be blamed, and large pendency of cases in the courts, low conviction rates, etc., are matters to be worried. That's why certain of the provisions are fine-tuned to fast-track the justice system. Citizen-centric criminal procedures are adopted. This is in tune with the outlook which the government has adopted, Sabka Saath, Sabka Vikas, Sabka Vishwas. So ultimately the move is towards that. There is a provision to press technology into service. Things are to be video recorded, statements are to be video recorded, and timeline is prescribed for the trial and for the pronouncing of the judgment. In cases where punishment is 7 years or more, the victim shall be given an opportunity of being heard before withdrawal of the case. Earlier it was total discretion of the state. Now victim also has an opportunity. And for petty crimes, summary trial, quick disposal, and accused may be examined through electronic means. See, we have to thank this COVID situation, because of which all of us are we were mounted on the horse of technology. Otherwise, we were happy with our button telephones and happy without, and many of us did not have even accounts in all these things. When things became compulsory, we learnt a bit of that, and now we have exposed ourselves. What is happening in the court, everyone is watching online. Common people are also logging in and all that. Okay. The existing law does not address the technological advancements. The country has changed. What is a copy? What is primary evidence? What is, see, when I have a DigiLocker and whatever you download from DigiLocker, everything is original. Everything is primary. There is no secondary evidence and all those things, how electronic documents are to be proved. All these things have come into place in the new system. When it comes to the point of punishment, you have a blend of reformative and deterrent theories. Deterrence is required, there is no confusion. Criminal justice system should not be a paradise for criminals. If I go for a health checkup, I have to pay minimum 5,000 rupees or 4,000 rupees, whatever. A person who is arrested immediately is taken to health checkup. Right? At home, if the food is not tasty, if I throw it, it will be thrown back on me. But in prison, there can be strike, there can be protest if the food is not good. You have heard of, no? Many a number of times prisoners will be on strike, that the amenities are not. So I take a small deluxe lodge. It is not so neat and clean. I have no way. If I shout, that fellow says, sir, hinge hogre allondu Taj West End anta alli daari ಐತೆ ನೋಡ್ರಿ, ಅಲ್ಲಿ ಹೋಗಿ ಸೇರ್ಕೊಳ್ರಿ, ಇಲ್ಲಿಗೆ ಯಾಕೆ ಬಂದಿರ? So because I cannot afford Taj West End, I have gone to this deluxe. Whatever it is, I should feel. See, now we have that freedom of feeling, no? When I can consider myself as a male or female as per the verdict of the honorable courts. Why not consider that I am in a 5-star hotel sitting in a deluxe room? Feel good factor. Okay. Deterrent punishments. See, why those people who were encountered in Andhra Pradesh, people appreciated, garlanded the police officers wherever they went. People appreciated, no? And even those who are learned in law also, they said, you have done the right thing. No, that is not right. But because our system is treating these people with all dignity, respect, and that's how it should be. In an accusatorial system, he is an innocent person. No, he is entitled to all that dignity. But common man will not understand what is happening. See, you will ask, you fellows, you are spending so many crores of rupees on this fellow Kasab who was caught on camera shooting down people in the railway station. What? Sir, it is all there in front of your eyes. Why trial? We are a due process country. We are a rule of law country. If it is some other rogue country, they would have eliminated them. But because it is a rule of law system, it goes according to the process. But it should be effective. Saddam Hussein's name was never printed with capital S in American press because he was enemy of the nation. Be careful whenever you write the name of anybody. First letter should be capital, including good morning, sir. S should be capital. If you want to insult that fellow, write small s. He may not be knowing, but I can feel happy. I have insulted. Sometimes it is nice not to know things. Because I know these things and this fellow sends me, good morning, sir, small s. Useless fellow, what are you doing? Oh, sorry, sir, sorry, sir. The teaching continues, even after retirement. Okay, so He was executed. Where he was buried? The news came that Saddam was buried at sea, at an unknown place. His grave should not be marked. The fellow should disappear, because a time may come when somebody will glorify this fellow to be a martyr of this, that, and so many things. Sometimes criminals are to be treated. This is in the ancient Roman system. A person who is, if an animal is sentenced to death, the flesh of that animal, the meat will not be used by human beings because that is condemned to death. That was the law. So, punishment should be deterrent, prohibitive sometimes. But whenever there is an opportunity for reformation, there should be a possibility, because beyond the wall, there is a university of crimes. This pickpocket fellow, the cheat, the thief who frequently visits prison will complete his graduation in crimes. As judges, you have seen how certain of the people have become hardened criminals over a period of time. He was picking pockets for his food. ಮಧ್ಯಾಹ್ನ ಊಟ ಮಾಡೋದಕ್ಕೆ ಅವನಿಗೆ ಊಟಕ್ಕೆ ದುಡ್ಡಿಲ್ಲ, ಭಿಕ್ಷೆ ಬೇಡಿದರೆ ಯಾರು ಕೊಟ್ಟಿಲ್ಲ, ಕೆಲಸ ಸಿಕ್ಕಿಲ್ಲ, ಏನು ಸಮ. ಬಟ್ ಓವರ್ ಎ ಪೀರಿಯಡ್ ಆಫ್ ಟೈಮ್, you have read this Otto Shankar's case and all that. So there is a problem. So don't send people beyond that wall. Beyond that wall, he will come in contact with the graduates, master's graduates in crimes, and they will tutor this fellow. And maybe they will recruit him into their system, their syndicate. So that's why protect, that is a combination that is tried here. Then this is what I am at. Community service is introduced as a new form of crime. What is community service is defined in the Nagarika Suraksha Samhita in one of the explanations to section 23. Community service means the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he is not entitled to any remuneration. Benefit of the community. For say, I am a law teacher. If I am convicted, the judge should order that I should go and take free classes in a nearby law college, teach them properly. Somebody is a musician, he should go to the park and play music every evening 1 hour. You go and entertain the people who come there for walking in the... You are a singer, you go and sing. You do not know anything, you go and sweep the area of Judicial Academy. Morning 6 you have to go clean the campus and come. That is the punishment for him. This has to evolve. This is not defined. Maybe over a period of time, depending upon the ingenuity of the judges, there will be so many sensitive things also involved here. Whether a non-believer can be sent to a temple to clean that premises will be issue. So many things will be there. That's why in one of the, from Karnataka, we made some suggestions. One of the suggestions we made in relation to community service was that it should be secular in nature. Otherwise, that will again create a lot of problems. Okay, so that is the thing. And here one of the observations is, this is not expiative punishment. There is what is known as expiative punishment. If a person has undergone that punishment, he comes out clean. Tomorrow if he has to file any application, if that column comes where you convicted for any offense, he can write no, because he has undergone expiative punishment. He becomes clean, as if not charged, not convicted. So that will be a sort of incentive that appears in plea bargaining. It is not there in Indian system. Elsewhere, that is a possibility. That is not there. These are the offences for which community service is contemplated. non-appearance in response of proclamation, public servant involving in trade, attempt to commit suicide, to compel or restrain exercise of law. Suicide is, attempt to commit suicide is decriminalized. At the end of that, they admitted that a person who wants to commit suicide will choose his time and place and he can escape any supervision, and there is no fun in compelling a person to live against his will. It is my body, I am in charge. Individual autonomy. There are two things. One is paternalism, another is autonomy. When it comes to the point of criminal law, there will be a balance between these two things. I take my daughter out. On the way, she asks, Papa, ice cream? No. Oh, what is the temperature? 27? No. You will catch cold. No ice cream. And pani puri. Pani puri. Look at that fellow's hands. Highly unhygienic. You will get infection. No pani puri. And at the end of that, I say, my darling, you want anything? I say, Papa, we will go back home. You are such an affectionate father. You care me so much. All of you ladies may have this experience. If you want to go for a hostel day, picnic, or birthday party, wherever, if your papa says, I also will come, you will feel bad. You will say, so I have cancelled myself. Papa, you will be home, I also will be home. I do not want to take you wherever I go. But father is a paternal figure. No, he is under a responsibility to guard the children. State is father to all of us. So this criminal policy is known as paternalism. Paternalism goes straight against individual autonomy. So of all the paternalistic, see, if you want to torment anybody, you can do unlimited tormenting in the name of the good of the person who is tormented. ನಿನ್ನ ಒಳ್ಳೇದಕ್ಕೆ ಮಾತಾಡ್ತಿದ್ದೀನಿ ಅಂತಂದೇಳಿ ನೀನು ಏನಾದರೂ ಹೇಳ್ಬೋದಂತೆ. ನಿನ್ನ ಒಳ್ಳೇದು ಅನ್ನೋದಕ್ಕೆ ಟ್ಯಾಗ್ ಹಚ್ಚಿಬಿಡೋದು ಅದಕ್ಕೆ. So that comes into criminal law also sometimes. Paternalism, now we are leaning towards individual autonomy. Attempt to commit suicide is decriminalized. But one aspect, threatening the government and compelling them to change the policy, it is a means of protest. We have to wait and see what will happen to this provision in days to come, whether it will sustain the scrutiny of the constitutional validity. Misconduct in by a public by a drunken person, defamation. Defamation, it was recommended by one of the committees that it should not be a crime. Now defamation is subject to community service. Okay, that's fine. Now new crimes, mob lynching. Some of us, we have honestly felt that the way people are beaten up in public with lathis to death, that cannot be tolerated in any civilized system. People have no business to take law into their hands and kill people on various grounds. Honor killing is there, maryada, communal, all these things. So that is a thing which is to be dealt with. Supreme Court has come out with series of judgments that is to be very seriously considered. That's why the provision says, shall be punished with death or with imprisonment for life. And yes, also, and maybe this provision is to be read in the light of the Supreme Court judgment in Jacob Matthew, that requirement of mens rea on the part of the doctor to kill somebody. Otherwise, doctors cannot. And you have this hit and run provision. There was a protest all over India by the truckers. If we stop there to report the accident, we will be beaten. So whenever there is a death in an accident, people will lose their temper and they will beat the person who has caused the accident. But that provision is retained. If he fails to report, then you will be committing a grave crime. Then you have organized crime. I don't know how many of you are acquainted with this system of organized crimes. No system is so well organized as criminals. Whether it is police, whether it is, what is that, black cat, greyhound, whoever, we are all, we say we are an organized society, organized system, but we are totally disorganized compared to organized criminals. If I go and volunteer myself to be a member of the crime syndicate, I will not be admitted because I will not qualify the tests. If you deeply study any organized crime, whether economic crime or some other crime, contract killing, gun running, drug peddling, whatever, you will find that they are so polished and perfected in performance. They have the efficiency of the highest order. They are totally professionals. They act together in concert. And consequences are very grave for them if anything goes wrong. There is a boss at the highest level. There are handlers. There are operators. There are recruiters. Veritable ways in which it happens. And discipline. They have a common enemy in the state. All of them. Drug peddlers, gun runners, trafficking in human beings, contract killings, land grabbing, all of them have a common enemy in the state. And the cooperation amongst them is so perfect that they will not run into problems, because if one fellow is caught, all of them will be running the risk. But with the administration, what happens? If you read N.N. Vora committee report and related things, Justice Lentil Committee and all that, I am Enforcement Directorate, he is Income Tax, he is Police. Police stumbles upon huge cash. It will not share that information with Income Tax, because every one of them want to go for a breaking news. If we share information, he will capitalize before me, because my investigation is not yet over. There is no cooperation between different enforcement agencies, state agencies, but there is perfect cooperation between different operators. They will do what they are ordered. See, a murderer will not take the gold chain. No, he is a professional, he will commit murder and get out. A robber will not commit murders unless it is so inevitable. Nowhere they will attack police people. They do not want to attract the enemy. They have their strong ethics. They will not bring in families. They are so well equipped with technology. Now, all these new crimes that have come into existence and which were organized criminals, very difficult, and organized crime is a new crime that has come into the system, rightly so. But the language used in organized crime is a sort of catch-all phrases. Certain of the language used, it is not defined. Anybody may be taken into custody, accused, and by the time he comes out, that is a different thing. There are words used like land grabbing. What land grabbing means? Not defined. Contract killing. What is that? Not defined. Cyber crimes. What cyber crimes? These new things are coming into existence. Nowhere it is defined. See, economic offenses, hawala transactions. This is very difficult to understand. Hawala transactions, crime-related, hawala transactions in import and export, how there will be inflating and deflating of the invoices and so many things. It is a very, very complex phenomena. All these things are not defined there. We have to wait and see how the jurisprudence will develop on that. Very, very stringent punishment is provided. Minimum punishment is provided for various offences, not less than 5 years, and fine, not less than. Being a member of the crime syndicate itself is an offence. For that also minimum punishment. Whenever this minimum punishment comes into picture, the hands of the judges are tied. Once convicted, you have to award him that minimum sentence. You cannot go below that. There is no question of taking the mitigating factors or extenuating factors into consideration. The discretion is, discretion with the judge is a trained person. He is trained how to exercise his discretion. If you deprive a judge of his discretion to quantify the punishment, the way out for him may be acquittal. In NDPS cases, it has happened. Maybe you know through your friends that innocent, some villager is picked up for possessing some ganja, this, that. Ganja, it is very simple. People in villages, there is a mutt, there is a swami, there is a sadhu, all of them, nothing wrong with it. So if some of them is, it grows like weeds, that is a wild variety. And sometimes it may be growing in my farm and I have not seen that plant at all. And it is growing right in front of me and somebody will come and arrest me because I am growing this in my farm. How many of you have seen a ganja plant? See, this is not necessary, no? Whether it is sweet corn to be seen and sometimes it happens. In Mysore it happened long back. We used to have antennas on houses for television. And early morning, somebody was meddling with the antenna, this duty constable, hey, what are you doing? Sir, we are not getting proper signals, that's why and then this fellow gave direction, in this direction, turn it like this, and went. That fellow stole that antenna and next day the police. Nowadays they telephone and ask us, no, my daughter will receive a phone call in my voice. See, maybe something has happened with my ATM, it is not, I have to pay, sir, so much of money, can you please transfer to this number? My voice, my phone number, my face. Why the child will not believe? Child will transfer, money is gone. Vice chancellors have lost money, police officers have lost money, judges I do not know, prosecutors. So nice, no? They greet us, wish us, and take money out of our pocket. So smart the criminals have become. They are operating from a place, they are trained. Okay, then this is their petty organized crimes. For me, organized is organized. Petty are huge, but for petty organized crimes also there is a minimum punishment provided. Then you have this Terrorist Act. See, some of you are aware of this principle that subtle laws are seldom obeyed, stringent laws are seldom enforced. If the law is very, very stringent and strong, that will not be enforced. If the law is very weak, delicate, nobody will care. There should be balance between these things. Stringent laws are necessary. After the Twin Tower blast in America, terrorist activities have come to a halt because they brought a legislation which is popularly known as Patriot Act. A terrorist is declared enemy of the nation. Anybody can kill him. Eliminate straight. You need stringent laws. And because they have brought that stringent law, nothing is going wrong there. And here, whenever a stringent legislation is, all libertarians, NGO people, human rights activists, all of them will. Stringent laws are necessary. If certain of the things, see, there is a possibility of abuse. Have a provision penalizing those who abuse the process of law. But stringent laws are necessary. If the society cannot behave, there is no way. Terrorism is a serious. Justice Malimat was very vehement. Who is a terrorist? He has no respect for human rights, and we should not have any respect for his human rights. A terrorist does not deserve human rights because he is not a human being. He is a different type of misled creature. That's it. Stringent laws, terrorism, terrorist act. Again, severe punishment for that. It has come there. Then you have acts endangering sovereignty, unity and integrity of India. Those colonial provisions. The historic trials by A.G. Noorani. A.G. Noorani has written a book, Historic Trials. Wonderful book. Therein you have the trial of Gandhi, trial of Tilak, trial of Adi Shankaracharya, trial of Ali brothers. See, we should know our history. Otherwise, we will not understand where we are sitting, for what reason, and what is the privilege that we are enjoying. Tilak was tried under sedition and sentenced. After so many years, Gandhi was tried under sedition. He was sentenced. And the judge therein, he had to convict Gandhi. Gandhi pleaded guilty. This was a very dangerous person for Britishers. If you contest, then something is possible. If you plead guilty, what you can do? What a judge has to do? He has to say, no, you are not guilty. He pleaded guilty, then the hands of the judge was, but judge was knowing what is happening. This is not an ordinary person. Mahatma Gandhi, before becoming Mahatma, was standing there. He was knowing that the whole world is watching. He was knowing that he will go down the history. Things will be recorded. And Ali brothers in the open court, they used to say, Judge, you cannot do anything, you have already written your judgment. But even then, let me make my statement. You do not listen, you sleep. But I will make my statement. They are very, very humorous fellows in the court. They were going to jail, but they were so humorous in the court. Shankaracharya will go and sit in the court, and judge comes, he cases a vote, he will not stand up. Judge, stand up. Sorry, sir, I cannot stand up. That is against my dharma of sannyasa. I am a sannyasi, I am not supposed to bow before anything else other than the God. If there is anything in your law to make me stand up, use it. I will impose a penalty. Penalty imposed, I will pay penalty. That's it. We should understand how this. So when it came to the point of sentencing, the judge writes, years ago, Balagangadhar Tilak, a great patriot of India, was charged under this section and he was sentenced to this term of imprisonment. Mr. Gandhi, you are no less a patriot compared to Tilak. And I will be failing in my duty if I am not giving you the same sentence which was given to Balagangadhar Tilak. This has that dubious distinction of trying the greatest of the children of India. That's why that had to go, that has gone. Sedition is removed. In its place, any separatist activity cannot be tolerated. Integrity of the nation is important. Nation should survive. If India is there, then we have all this freedom, everything. We can speak. Between Russian and American, there was a debate. Americans, see, we have Statue of Liberty. In our country, we can go to White House and scold our president. Then Russian answered, we also have liberty. We can go to Kremlin and scold your president. We cannot talk anything about our president. Fun, okay. So, country has to survive. If you read the essentials of a good constitution, unfortunately, we are not taught, we are not trained to consider how the constitutions are to be looked at. There are certain of the essentials of a good constitution. One of the essentials is organization of liberty within the constitution so as to keep it beyond the reach of any brutal majority. Any party with any majority cannot touch. Tyranny of numbers cannot affect liberty. This is one. Second, having done that, there should be a provision for temporary suspension of liberty within the constitution. That is one of the requirements of a good constitution. So, if it comes to that, we should be ready to forego our liberty, and liberty will be taken away constitutionally as authorized by the Constitution, because anything that threatens sovereignty and integrity of India cannot be tolerated. Separate chapter, sexual offences against women, children, voyeurism, all these things have remained as they are. Okay. So, we have these new dimensions, combination of different types of punishments, reformative, deterrent. We are moving forward. Doxing. How many of you have come across this word, doxing? Did you come across this? Doxing is in existence for the past 3-4 years. Later you will Google and make out what is the meaning of doxing. Cyber kidnapping. A police officer in Bangalore was cyber kidnapped. A businessman was cyber kidnapped. Some children were cyber kidnapped. This is a new thing that has come into existence. Now, the criminal knows that C.S. Patil is delivering a lecture here in Judicial Academy. C.S. Patil's daughter also knows that her father is delivering a lecture in Judicial Academy. So, they will contact my daughter and say, look, right now your father is there. 11:20 he was supposed to come out. 11:21, 22 he has not come out. The moment he comes out, he will be shot dead. Our sharpshooters are standing there. He is involved in XYZ crimes. There is a parcel that is received in his name which contains narcotics seized at Bombay airport. So many things. This child will get scared. Then they say, if you want to save your father, you isolate yourself. Don't be accessible to anyone. Don't receive any phone calls. Switch on your camera, sit there. So the child will switch on the camera, that is under the supervision of those people. She cannot contact anybody. She cannot be contacted by anybody. Then they will call me. They say, your daughter is in the Harvard in such a place. Yes, we have kidnapped her, we have taken. She is in our custody, she is not in your home. Then I frantically try to reach my daughter. Daughter has isolated. Mummy knows nothing. Cousin knows nothing. Nobody knows anything because the girl is under their direction, supervision. And she wants to save the life of her father. I will be put under impression that the child is kidnapped and I am asked to transfer the ransom. A police officer, it appeared in the newspaper, a police officer he received a phone call that you are so and so, this, and maybe he had some dubious record also. Then they said, ED people are standing there outside. The moment you come out, you will be arrested. You will be taken into custody. And this officer was made to transfer for about huge sum. say 20-30 lakhs of rupees he has transferred. He was under arrest, cyber arrest for about 3 hours. Till his daughter came into his room, he did not know that it is fake. When the child entered the room, Amma yang bandama, hige bande, ಹೊರಗಡೆ ಯಾರಿಲ್ಲ. This fellow, he felt the moment he goes, enforcement people will take him into custody. And he parted with huge sum for about 80 lakhs or something like that. That is cyber kidnapping that has come into existence. Cyber rape. You have this box-like thing fitted on your eyes, Meta. You will feel that you are really going there, doing things and all that. Psychologically, this is what I read in the newspapers. I do not have much information about cyber rape. The mental, psychological aspect, the trauma and agony is equivalent of undergoing physical rape. That is the report that I read. That is cyber rape. Deep faking. Right now, I was informed yesterday that this is live streamed. As I am speaking, it is being aired. People are listening. Anybody can listen with that link. Meta has announced for about 15 days back that they are going to release OpenAI. OpenAI. You have ChatGPT. How many of you have tried your hands on ChatGPT? ChatGPT. Yeah. If you have tried, you have to raise your hand like this. Huge. See, you are technologically... ChatGPT is years old, ancient. I registered myself. It was a mad rush to register for ChatGPT. Now it is open. You can just open Google ChatGPT. Give me a note on Keshavananda Bharati in 10 pages. Not even 1 minute, you will get a note of 10 pages on Keshavananda Bharati. Next you say, give that with footnotes. It will give it with footnotes, with subheadings. I have given my student a topic on domestic violence. You have to write a essay on domestic violence. The fellow in 1 minute he will come. Critical evaluation of Domestic Violence Act. You will do that. Criticisms, appreciation. Anything you ask in less than a minute, you get it on ChatGPT. It is open. Anybody can use anywhere. This is one. Now AI, artificial intelligence. They have said, Meta has said, it is going to release OpenAI. Anybody can log in and use that OpenAI. Okay? And if they get 45 seconds of my speech, not minutes, seconds. If I get a video clipping of mine, 45 seconds, they can make me speak hours and hours what they want. I will be speaking what they want in my tone, tenor, body language, accent, everything. That's what they can create. Deep faking. Deep faking appeared in the last election of Delhi. And this election, lot of deep faking has taken place. Technology is moving. Crazy sometimes. But we have to believe. When I was reviewing a legal thriller novel, Pirates of Bollywood, therein I stumbled upon one expression. What is that? Piracy rights. Piracy rights. Piracy is a crime. Pirated CD, pirated books and piracy rights in movie world. I wrote a review and sent it. Maybe it is a novel. No, they have imagined things and all that. And later, when I met Justice Banurmat, I asked, sir, when I was reviewing a novel, I came across a thing like this, piracy rights. Is it, because he was heading Human Rights Commission of Maharashtra, he said, Chidanand, where you are, crimes are also sold in Maharashtra. There is a business in crimes. What about this? Things are happening. There is always a race between Kalla and police. Kalla is always in front, police goes after. And we are there to administer justice. And criminal justice system has to run leaps and bounds to catch with the criminals, and especially with the technology in place. It is a challenge to the lawmakers, interpreters, and all of you who are in charge of translating that law into reality. Thank you very much, and beholden. Yeah, this is theirs.
Thank you so much, sir, for your detailed overview of new criminal laws and highlighting the contemporary challenges of new crimes that are emerging. On behalf of everyone present, I extend our heartfelt gratitude for sharing your profound knowledge and expertise with us today. Thank you so much, sir. We will have tea break now and we will resume sharp at 12 noon.
Good afternoon, all. I once again welcome all the participants to the second session of the first day of 3 days workshop on Capacity Building Orientation Program on New Criminal Laws 2023. Well, it reminds me one of the quote of the former Indian President, Dr. APJ Abdul Kalam, who said, "Learning is an ongoing process. It gives creativity, creativity leads to thinking, thinking provides knowledge, and knowledge makes you great." So we all are here to learn, create, think, enhance our knowledge, and become best. In this session, to enhance our knowledge on the new Bharatiya Nagarika Suraksha Sanhita 2023, we have distinguished resource person, Sri E.V. Chandru, alias E. Chandrasekharan, Advocate, Chennai. Vanakkam, sir. I feel delighted, honored, and privileged to introduce today's resource persons to you all. Mr. E.V. Chandru was born on 13/11/1972. He obtained BA degree from Tagore Arts Government College, Pondicherry in the year 1994. He obtained LLB degree in the year 1997 from Ambedkar Law College, Pondicherry. ME degree in the year 2014 from Madurai Kamaraj University. LLM degree in the year 2018 from Annamalai University. And post-graduation diploma in the year 2014 in Yogic Sciences and Naturopathy. He got enrolled as an advocate on 30/7/1997 with the Bar Council of Tamil Nadu and Pondicherry, and he has put in 27 years of experience, and he has appeared before various trial courts and tribunals in Tamil Nadu and Pondicherry, and Honorable High Court of Judicature at Madras, and conducted cases in various branches of law. He is attached to the Office of Senior Advocate, Mrs. Vrinta Mohan, Pondicherry, and designated Senior Counsel, Mr. N.R. Ilango, Chennai, and he has his chamber at Chennai. He is empaneled as panel advocate to appear on behalf of Registrar General, High Court of Madras, and District Judiciary, High Court Legal Services Committee, Chennai, Tamil Nadu State Legal Services Authority, Tamil Nadu Generation and Distribution Corporation Limited, Administrator General and Official Trustee, High Court of Madras, and Pondicherry Legal Services Authority. He has presided as member in many national Lok Adalats, along with Honorable Judges of High Court of Judicature at Madras. He was special invitee for the Criminal Rules Committee 2021 and 22, High Court of Judicature at Madras. Special invitee for the Juvenile Justice and POCSO Committee 2022, High Court of Judicature at Madras. Special invitee for state-level consultation meeting on the key challenges regarding justice for children and child in conflict with laws by Tamil Nadu State Judicial Academy 2023. As a resource person, he participated as panelist to address on BNSS 2023 held at New Delhi on 20th/4/2024 in the presence of Honorable Chief Justice of India, and at Guwahati in the presence of Honorable Central Home Minister, organized by Department of Legal Affairs, Ministry of Law and Justice, New Delhi. As a resource person, he is frequently visiting National Judicial Academy, Bhopal, and delivering lectures on various law subjects. Apart from that, as a resource person, he was called by Tamil Nadu State Judicial Academy, Jharkhand State Judicial Academy, Madhya Pradesh State Judicial Academy, West Bengal Judicial Academy, Gujarat State Judicial Academy, Tripura State Judicial Academy, and Ladakh Legal Services Authority to deliver lectures on various law subjects, including new 3 criminal laws. He is also a resource person in law subjects to CBI, Sardar Vallabhbhai Patel National Police Academy, Hyderabad, UNICEF, Tamil Nadu Police Academy, Anna Institute of Management, Chennai, Public Prosecutor Office, Madras High Court, Pondicherry Police Training School, Pondicherry Chief Secretariat, and to the Department of Social Defense, State Child Protection Society. He has worked as a guest lecturer in Ambedkar Government Law College, Pondicherry, Puttupakam, Annamalai University, Chidambaram, Tamil Nadu, and Dr. Ambedkar Global Law University, Tirupati. He has bagged several awards for his achievements. He was also recommended as one among the 2 nominees for Nyaya Bandhu Best Pro Bono Advocate for the year 2023 by the Honorable High Court Legal Services Committee, Madras High Court, to the National Legal Service Authority, Supreme Court of India. He has imparted legal knowledge to the thousands of students and advocates from 1996 till date. Sir is traveling extensively all over India, imparting knowledge on new 3 criminal laws. I must mention that when I contacted Mr. Chandru sir over phone and requested him to come to our academy and deliver lecture on new BNSS 2023, sir said to me that he is from Tamil Nadu and his English language accent is mixed with Tamil language accent, and asked me whether officers of Karnataka will be comfortable to hear him and understand his lecture. So I said, the most important thing in communication is to hear what is being said. And I told, being different linguistic and belonging to different region is not a matter of concern when it comes to parting knowledge. And I told him that we all are very much keen and eager to hear his lecture and requested him to come to our academy. Sir readily agreed and is here with us today. I, on behalf of Karnataka Judicial Academy and all the participants present here, heartily welcome you, sir. In this session, I request Sir to grace us with his insightful thoughts and enlighten us on the new Bharatiya Nagarika Suraksha Sanhita 2023 with special reference to provisions related to FIR, investigation, arrest, remand and bail with special reference to Satyendra Kumar Antil versus CBI, Arnesh Kumar versus State of BR, and provisions and reforms related to proclaimed offenders, trial in absentia, evidence of public servants, experts, etc. Thank you very much. Over to you, sir.
Yes, good morning, everybody. At the outset, I thank the Honorable High Court, Karnataka, and the Board of Governors. Okay? Yes, the Board of Governors, the Director, Karnataka State Judicial Academy, and my special thanks goes to Satish sir, who has put me in a lot of shyness and embarrassment for a very long time, and he was pestering me for around 20 days. He was very magnanimous that I readily accepted. My evasive tactics could not be adapted with him. Somehow he saw that I will be here. I am thankful for you all. With the blessings of my parents and my senior and teacher, Mrs. Vrinda Mohan, an advocate of Pondicherry, I am in front of you. At the end of tomorrow evening, tomorrow afternoon, if something is useful, it is because of my senior's teaching. Okay. So don't give any credit to E.V. Chandru. If at all anything shabbily said, wrongly said, then you can, the credit is for me. In a way, I owe so much to Karnataka. My elder brother has left Tamil Nadu after finishing his B.Tech and MBA. This soil, this state was kind enough to accommodate him in a job 30 years back. He is attached to Karnataka. He has become the son of soil of Karnataka. So part of my brother's blood and bone, marrow, everything belongs to this soil. So in that way, I find this as an opportunity to repay what my brother has taken from this state. And so I am not new to Karnataka. I have been to my brother's house often, and from 97 to 2023, because 97 I enrolled. After enrollment, people don't give you any bundle. So anywhere anybody calls, you will go. Okay, in that score, this state has also given me an opportunity for 5 to 6 years up to 2023. Even for a caveat, I will come from Tamil Nadu to Karnataka. I still remember 98, I think, in some city civil court, somebody, they arranged for a car, ambassador car, and he brought me down from Pondicherry to Bangalore. I arrived around 8:30 or 9 o'clock. I do not know the places and all exactly. It was full of darkness and we were searching for food. It was only 8:30 or 9 in the night. I am talking about 98. I think thereafter the scenario and all changed. Now 24/7 we are having everything. So, and at last, Satish sir has caught me. I do not know where from they caught me. They caught me and I was very happy when he called. He called my one junior in Pondicherry. Through his number he caught me. So I am in front of you. If at all you have to praise or scold also after tomorrow afternoon, you should do only him, not Chandru. Okay? And it will be very difficult to see one face for more than 24 hours. I cannot help it. Right? Sometimes marriages also makes you to do like this. No, you have to see a face for 3 or 4 decades. And like that you adjust with me for one day. Right? Then what is? And Satish sir was reading a profile, right? And Chandru is not worth of anything in that, right? It is, once again I'm telling, it is all the good parentage I enjoyed. I had a very nice father, nice mother. I belong to a lower middle class family. My father was a dentist. And he is such a loving man that in spite of all my mischiefs, don't come to any conclusion that I am a good person, seeing all this, right? I was one of the most idiotic, mischievous fellows. And to my 10th standard, he was reading after my 11th standard and 12th standard records, right? I should be truthful enough. A man without truth, no, Saraswati will not be in his tongue. So up to 10th standard, I had the great achievement of taking 0 in maths. Invariably, any maths paper, I am not at all interested in reading. I do not know why. Perhaps I don't like my teachers, or the love which I am enjoying with my parents are more than what the love that I enjoy from my teacher. But whatever it is, I had a good parents, good brothers, sisters, good neighbors, and good silent soil. Tamil Nadu, it is not like Kashmir where people fought. So any credit of mine should go to the country, the state, my parents, and good senior. My senior's office starts by morning 6:30, 6:45 every day, right? Mostly it will end in 2 o'clock or 2:30 in the morning. This happened, I was in her office for a very, very long time, more than 15 years. And another one good thing is, 3 days you will be provided, all juniors will be provided breakfast, meals, and also dinner. Such sort of godly lady she is. Now also she has got some 12, 13 juniors. It continues like that from 1997. And she paid me 2,500 rupees in 1997. Right? It was a very good amount in 1997 for a junior. And so I had all good people around, and I have never met any bad people more bad than Chandru, right? That is the reason uh, there are something meritorious in my tale, that's all. Okay, we'll come to the serious part of it. This is Bharatiya Nagarik Suraksha Sanhita, right? Because we have a time up to tomorrow afternoon, I am planning to schedule it in such a way that I will just come out of the schedule which Academy has given. We will start from section 1. We will try to finish it up to 5:31. If Academy permits me to take a session like that, I think we will just cover everything. What are all the changes, what are all the vital changes, and in a practical way of thing. We will start by section 1 and we will try to finish it up to section 531. You agree with that? Yes. Yes. In democracy, consent is very important. That too with judges, no, I should be very careful. So tomorrow for the defendant. So advocates, we are all bad people. If you want me to speak for the central government, I will say, impliedly they have said that Nagaland alone is excluded. So using the implied clause, you should impliedly mean that for other states, it is applicable. This is for speaking for the central government. If you want me to speak for the state government, especially your state government, then I will say this is poorly drafted. It ought to having mentioned in the margin, short title extent, they should have mentioned extent. Okay. So the debate, it is food for thought. You keep worrying on that. I will come to second section. What is section 2? Section 2, subsection 1, small a is very, 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 very important. Right? What does it say? It speaks about audio, video. Yes. One thing is, electronic evidence is also considered as a document, and it has received a definition in Indian Evidence Act, that is the Bharatiya Sakshi Adhiniyam. However, digital documents are not defined. This is one thing. Please note that what is digital document is not defined in any law. So where we should see Bharatiya Nyaya Sanhita, Bharatiya what is this? Bharatiya Nagarik Suraksha says, section 2, subsection 2 says, if anything is not defined in this, you should see Bharatiya Nyaya Sanhita. And if something is not defined in Bharatiya Nyaya Sanhita, you should fall back on IT Act. Okay. So if anything is not defined in BNSS, you should see BNS. If in BNS it is not defined, you should see IT. But in all this, digital documents are not defined. So please note that digital document is not defined. Perhaps it will be defined in rules which the state government may also make. So presently, the old definition in Indian Evidence Act that documents are something inscribed on a surface. Right? We will see many documents in public lavatories also, in park trees. Have you seen in any public lavatory you go, in all the walls, in all the doors, because they will take 15 minutes, half an hour of other man's time, no? So they will keep on documenting so many things. In public parks also you see. But in our houses, we will not spoil our walls. We are very conscious people, good people. We will spoil only public places, right? Now these documents, earlier we were writing on the floors, on the sand. Then thereafter leaves came. Then thereafter paper, then slates, then boards with marker. So now the dream of the parliament through section 2, subsection 1, small a, read with 530 of CRPC, that is BNSS. Please go to BNSS 530. This is the vision or dream of the parliament that courts, investigating agency and all organs will become paperless. Right? What BNSS section 530 says? It says everything. To put it short, 530 is the vision of the parliament that investigation, inquiry, trial, judgments, appeal, all will become electronic in electronic mode, audio, video, and mobile phones are going to play a very, very vital role. Right? Previously itself, no, mobile phone is a big headache. You cannot live without, you can live without wives and not mobile phones. Right? It has become like that now. So 530 is the vision of, if you have to understand the present criminal laws, you should read 530, which says issuance of summons, execution of summons, proof of summons, search, seizure, everything will become paperless. Everything will be in audio, video, electronic mode. Okay, so this time is a transitional period from paper to paperless investigations and courts. This is what section 530 says. Section 2, subsection 1a, you can read one judgment, which is the judgment of the Honorable Supreme Court in State of Maharashtra versus Dr. Praful B. Desai. State of Maharashtra versus Dr. Praful, P-R-A-F-U-L, Praful B for ball, Desai, D-E-S-A-I, 2003, Supreme Court. Okay. What does this judgment said in 2003? This was a judgment in the Supreme Court where a question before the Supreme Court was whether the presence of a witness in physical mode can be replaced by virtual mode. 2003 judgment. A man was in a foreign country. Can he depose as a witness through audio video means? In 2003, definitely Supreme Court would not have prophesied, thought that things will become like this. So please read Dr. Praful B. Desai's judgment, which says presence of a person in physical mode can be substituted by virtual mode. That is the brother judgment for us before this act. Okay, please read that judgment. I will trace so many judgments of the Supreme Court which has in a way contributed for the amendment of CRPC. All these amendments which we find place in BNSS today are the result of so many Supreme Court judgments, and these judgments were recommended by the Law Commission to the Parliament Standing Committee. These judgments were translated as amendments. So one thing is these amendments, but for some amendments, 4 to 5, all other amendments were already put to test and were declared by the Supreme Court. So I think the present law will work, but anything which is new, no, we will have a what? We will have some hesitation, right? Even for new marriage, no. How many of you were scared when you got married? Oh, you are all brave people. Nobody is raising the hand. You are all very brave. My brother called me yesterday. He asked me, Suja, he will call me as Suja. Suja, did you reach Karnataka? I said, yes. He has went to Bijapur, so he was not here. He said like this, what are you going to eat? I said, I have to go to canteen. Everything will be very nice, right? Second point, Karnatakas are very good people, very sweet people. They don't fight unnecessarily. Always, my brother gives you a certificate, every time you will say, they are all very sweet, very good, peace-loving. That is the reason I said his blood, bone and marrow has got Karnataka inside, right? Very peace-loving people. Suja, be careful, they are intelligent also. Okay, so he has made me not to sleep also, right? So section 2, subsection 1A is like this. Please read that Praful B. Desai's judgment also, right? Then we'll okay. Section 2, subsection 2 also we have dealt with. Then for the first time, section 2BDE, BNSS, section 2BDE, bail, bail bond, bond was defined. I will just put it simply to you. You need not break your head much. You can remember nicely. What is bail? A man in a legal custody, either in a police custody or a court's custody, is given custody to a private person. A man who is in a lawful custody was placed with the responsibility with another one fellow that this fellow should cooperate and receive the judgment. This is bail. What is this bond and bail bond? Bond is personal binding of that fellow. Bond is binding. Remember like that, we will not forget and we need not remember that also. Bond is binding. What is that? He executes a bond and binds himself. Bail bond is making another two persons to stand for him. Okay, this is what is said in section 2. You understand, dear judges? Yes. Bond is binding, personal. Bail bond is someone else is giving guarantee. No, at the time of marriage, the father-in-law and mother-in-law stands as bail bond. Okay, they are the sureties. And if it comes to bond, the bridegroom says, I bind myself to the wife. Okay. Not married, no, I have the advantage of speaking anything with regard to this topic. You should get scared for your wife or husband. Right? 2 subsection 1 subsection I. electronic communication. This was also introduced. Then 2 subsection 1 subsection L, investigation, explanation is important. 2 subsection 1 subsection L, investigation. Okay. Who is the youngest magistrate in this group? Youngest magistrate. Question is only simple, my dear. Please raise the hand. Okay, any magistrate can raise your hands. Any magistrate? Amma, the question is, investigation is the domain of whom? I can give only 50 marks to you. See, previously it was section 2 subsection H. Now it is 2 subsection 1 L. Investigation is collection of material by the police or by the magistrate, not by the magistrate, but by any person authorized by the magistrate. So please don't imagine always that investigation is the sole regime and realm of police. If something like that is there, then there is no business of 156(3). Suppose the complainant comes and stands in front of you stating that there is no proper investigation, what are you doing? You are asking the police to do proper investigation, fair investigation, speedy investigation, further investigation. 4 investigations are in the domain of district judiciary: proper, fair, speedy, further. Okay? All 4 district magistrate district judiciary can order. De novo investigation, re-investigation and investigation through CBI, all these 3 are the domain of constitutional court. I repeat, fair, proper, speedy, then further investigation. All these can be made by district judiciary. Constitutional courts, High Court and Supreme Court can order for a re-investigation, de novo investigation and investigation by the CBI, because you cannot order for a CBI investigation, right? 2H says investigation is collection of material by the police or by the magistrate, but magistrate cannot do. Why magistrate cannot do an investigation? He cannot become a judge of his own cause. He cannot ask somebody to investigate. He cannot investigate himself, and he cannot judge the case. But magistrate can authorize any person. You see the word any person. So legislature believes that if the police is not investigating properly, magistrate has got the power to authorize any person to investigate. So please don't think that police people alone can do investigation. You are the supervisory authority and you are also the body empowered by law to authorize any person. See the word any person, what amount of faith the legislature has got on judges. Okay, this is one thing. Second is, reading of section 2(1)L says, investigation is collection of evidence. Is this word right? 2H also it was there. They are telling it as investigation is collection of evidence. Is this word right? We will start from the beginning. Is the word collection of evidence is right? There are only 2 things possible. One is Chandru will learn from you, right? And Chandru is not going to give any marks. I am your friend from a neighboring state, that's all. So you can say anything. I can also equally bluff. Okay. Yes, please tell me whether section 2H or 2(1)L, which says investigation is collection of evidence, whether this word collection of evidence is right or wrong. Say why. Okay. Evidence Act says evidence means, oral evidence means, any disturbance here, sir, in this? No, slowly, please. don't have anything. My charge or phone? Judges, we should be very careful in addressing. Charge has come down means whose charge? I cannot ask your charge. So I asked whether my charge. Okay, but some charge has risen up. Thank you, Assistant Director. See, Section 2, Section 3 of Indian Evidence Act spoke about evidence, oral, documentary. Now it is Section 2 of the Bharatiya Sakshi Adhiniyam, right? They say, Indian Evidence Act say, evidence, oral evidence means statements made on oath in the court with regard to fact in issue, which the judge either requires or permits. I am repeating for the welfare of the magistrate, dear children magistrates there. Evidence means section earlier 3, now 2 says, evidence means, oral evidence means those statements given on oath which are required or permitted by the court to do so. What is the difference between requiring or permitting? Please read section 3, somebody, some small children in the behind. See section 3 or section 2, read that oral. Am I not visible to this row? It is also good not to see my face for a long time. Yes. Please read section, please give the mic. Do you have a hand mic? You can help some judges by giving the mic. Judge, please read section 3 evidence or section 2 oral. Evidence oral. Somebody can read without wasting the time. Judge, have I got a book? Anything. Please read oral. Document, evidence oral. Section 2 also it is there, no? If it is old act, it is section 3. It is new act, it is section 2. Evidence means and includes.
All statements. Evidence
Please listen.
includes
Yes, Judge.
statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence.
See, now go to section 2, subsection 1L of BNSS. What it said? Investigation means collection of evidence. What here it is said once again? Our judge has read that oral evidence means statements made in the court which the court either permits or requires with regard to fact in issue. Judge has to answer an issue in consideration, a fact in issue. For that, if the judge permits a man who is in the box not to speak something irrelevant, right? Now, two words are there. One is requires or permits. What is the difference between that?
Relevancy.
What is it? Okay. See, you can explain me this concept like you are explaining it to a villager. You are all talking like judges now. See, what is the basic difference between Evidence Act says oral evidence means a man is in the box. He cannot come like that. Either the court should require or court should permit. What is requirement? See, I was given a room in the state judicial, what is that, state academy, what is the state guest house, right? I was given one bed. Required is excellent, judge, beautiful. Permit is excellent, excellent. See, permitting means, requirement means, I was given one bed yesterday. I want additional things or more things, I ask. Permitting means there is already in all civil cases a list of witness that was given by the plaintiff, list of witness given by the defendant. You permit that fellow to be examined because it is already there. Section 165, Section 91, Section 311A, all will stare at your face. Suppose you want to unravel the truth, you require something more than what is already given, you have permitted something. Now the requirement comes when you want to unravel the truth more. So, Section 165 is reflected in Section 3. Now coming to this is requirement and permitting. Permitting means it is there, it is standing near your gate. You say, yes, you come. See, I am standing there, you are telling, yes, without permission, don't come. Then you say, yes, I am permitting, come inside. Because list of witnesses by the prosecution, by the accused, by the plaintiff, by the defendants, already there, you are telling, yes, I am permitting this witness. Or you will ask, what is the requirement for this witness? Requirement is, as our judge also has rightly said, you require more. Today morning, Satish sir gave me only 2 idlis. What I said, I want one more. This is requirement. Now, at this juncture, I want to explain something more on that for the benefit of the magistrates. Trainees here. Okay, any trainees judges here? No trainee judges. Yes. One is, an evidence, the word evidence is used in CRPC section 2 subsection H of CRPC. Now it is 2(1)L in a looser sense that police people are collecting evidence. It can never be imagined as evidence, or if you want to call it as evidence, it is a prima facie evidence and not a legal evidence. Okay? So that is not a evidence. It is prima facie collection of materials which legislature uses a loose word called as evidence. So what happens? This evidence which is collected by the police, as mentioned in CRPC, is called as material or police report. This police report can never become evidence. Virendra versus NCT Delhi, VIRENDRA, Virendra versus NCT Delhi, right? Supreme Court, I think it is 97 judgment, Virendra versus State, NCT Delhi. In this, the Honorable Supreme Court says, report collected, materials collected by the police, please listen this very carefully, how beautifully Supreme Court says, materials collected by the police has to be translated into legal evidence in court. Materials collected by the police has to be translated into legal evidence in the court. So, even if you think that what the police have collected it as evidence, it is not. I used one prefix. Legal evidence, excellent. Legal evidence. Supreme Court says, materials collected by the police and presented as police report has to be translated into legal evidence. Where? In which place? Box. Why? Then only it will become substantive evidence. A man who speaks or gives evidence in the box is called as substantive. What is substantive? Substantive is real. Right? Evidence given in the box on oath is called as substantive evidence. Point 1. Whether this evidence, substantive evidence, is substantial for answering the fact in issue. See, now we saw prima facie evidence. Supreme Court said it should be translated into box as legal evidence. That is called as substantive evidence. This substantive evidence should be substantial, adequate. What for? Answering the issue, either negativing it or affirming it. This is called as substantial. Okay? If it is substantial, court will not require for more evidence, because parties themselves have already provided. If it is not substantial, court will require for more evidence. Then based on the truth in the evidence, using section 114 of Indian Evidence Act, see, every day I will request all the judges to read section 114 every day. What 114 says? It says, court presumes things on the scale of a reasonable man. That's all. Whether the story projected by this fellow is probable or that fellow is probable. So, who a judge is? That is the reason it is often said a judge is a person who knows no law. Wow, who a judge then is? A judge is a man of rich common sense. and he should work within the framework of law. That's all. Judge is a man who is a wiser man, W-I-S-E-R. He should work with adequate common sense. Right? Some 2-3 months back, had any of you met me in NJA? Any judges here? Some 2-3 months back, in NJA, I was taking a session on PMLA, Money Laundering Act. 2 judges raised their hands and was asking questions on community service, because that headache is also there for you, right? One judge, district judge, asked a question, Chandruji, in Madhya Pradesh High Court has ordered for a community service. Then he told what it is. He said, judge has ordered a man who is a woodcutter, illegal woodcutter. He goes to the forest, cuts wood. Then the judge said, you come here, you seems to be very poor, I am not going to send you to jail, you plant 20 trees. The accused is hereby direct sentenced to plant 20 trees and report within a week. Questions by the judges in NJA. Point 1. On whose land he should plant? After planting, who will water it? How long it will be watered? Who will take care? The judge has ordered for community service only one line. See, these are all out of frustrations or anger, because the judge thinks this fellow is slaughtering everything. He wants him to plant. Whose land? Whether it is in judge's bungalow or chief minister's bungalow, because those two are very big. These little people, they live in small huts, or they are living in small LIG or MIG. Where is the place to grow 20 trees? So a judge should be a man rich in common sense and should think that whether this story is probable or what I am telling will be implemented. So judgments need not be given for the purposes of reporting in papers every day. First thing a judge should think is whether this is implementable, whether my judgment will be respected. You can see every day so many judgments coming out. Can you implement all those things? Many judgments you cannot implement at all. Right? So this is what section 3 says. So substantive evidence, probative value of the evidence. Last thing is probative value. What is probative value? Whether it is sitting in common sense or not, whether the version projected by him has a real value or it is sitting in the common sense. I have told you already, you as a judge, in a way, you are all very pathetic. 2 fellows capable of speaking only lies are standing in the name of prosecutor and defense. What a poor judge will do? That poor judge has not seen the scene of occurrence. He do not know the ABCD of the real truth. You have to somehow believe the stories projected by either the prosecutor or the defense, and you should think whether it is in common sense. Whether it would have happened the way he is projecting or whether it would have happened in the other way. This is what section 3 evidence expects. I want to impress upon you all on section 2 subsection 1L that investigating machinery, the documents that is produced by him is useful only for one purpose. What is that purpose? Police report is useful for only one purpose. Sir? Prior to that, first purpose. What is the first purpose of the police report? Excellent, Judge. Excellent. You give a big clap for Judge. My brother yesterday said Karnataka people are very good. Clap is not at all good. See, if you clap more, we should always have the heart to appreciate people. You clap more, it is good for your heart. You know that. And can you clap in a court? Even if you feel that the advocate is amazing. So this is an opportunity for, see, I went to Jharkhand 6-7 months back. They called me for for participating in flag hoisting because the session is in 10:30, right? I went there by 10 o'clock itself. Around 60 judges, all district judges, and they were all very senior judges, it seems. I felt as if I was in a college farewell day, because all these 60 judges are just very energetic. They are all singing something, talking something. I felt that it is not a judicial academy at all, Jharkhand. They were very happy, enviously happy. Right? I cannot hold it inside. By 10:25, I went to director's room after all this. I said, Judge, what is this? Your people are behaving like this. They are all just shouting, just singing something, very noisy it is. He asked me why it should not be like that. See, he told this is the only place where my people can come, relax, rejoice, at least openly speak. Right? So when I ask you to make a clap, no, you may not perhaps get the chance day after tomorrow. Huh? So if you can clap for him. See, what was the question? What was the answer? What do you said, Judge? For cognizance. Police report is material only for enabling the judge to take cognizance of the offence for the purposes of getting satisfied that the way in which it was said, I can issue a summons to a man to come and answer, that's all. Otherwise, any evidence either for prosecution or for conviction or acquittal, you can see only evidence, that's all. Okay? So you remember that. From that, where we can go? Okay. Then coming to section 2, subsection 2, we have discussed what it is. If it is not defined in BNSS, you should go to BNS and IT. Then section 4 and 5 we have already finished. Section 4 and 5. Who you should remember in section 4 and 5? Mother or daughter-in-law? Both. Section 4 and 5. Right? Section 6. Who are all metropolitan magistrates here? Any metropolitan magistrate? Judge, you will not be a metropolitan magistrate day after tomorrow. Right? From first. You are feeling sad or happy? But norms will be very difficult for you, no, in civil court. Who are all assistant session judges? Assistant session judge, there is a post in Tamil Nadu called as assistant session judge. They are above CJM. CJM will give a punishment up to 7 years. Assistant session judges will give a punishment up to 10 years. And two things were effaced, removed. One is metropolitan magistrates will not be there. So you cannot go and say, I am a metropolitan magistrate, because you think magistrates in villages are inferior. Because of their curse, no, for 70 years. See, these metropolitan magistrates, no, they think they are really big magistrates. So the curse of normal judicial magistrates has worked, sir. Okay. So metropolitan magistrates will not be there. Assistant session judges will not be there. So who will be there? Magistrate, Chief Judicial Magistrate, Session Judges, High Court, Supreme Court. So this section 6 you should read with section 22 and 23. You just mark in the book, in the margin, section 6 should be read with section 22 and 23. Then section 15. What section 15 says? Special Executive Magistrate. This section 15 should be read with section 162. Okay, please jot section 15 to be read with section 162 BNSS. Okay, whether in Karnataka, police commissioners are having powers of executive magistrates? No. Tamil Nadu also it is not there. But from 1st July, the superintendent of police, in the rank of commissioners and superintendent, they will also become special executive magistrates from 1st July 2024. So please note that section 15 and section 162. Then section 18. What is section 18? Public prosecutors. 18 subsection and 18 subsection 1 proviso. 18 subsection 1 proviso. What it says? For Delhi, who is the Chief Minister of Delhi? From 1st July 2024, Arvind Kejriwal will not be appointing public prosecutor. Who will be appointing? National Capital, for National Capital, central government. Okay, that is their headache and business. I am just telling for information purpose. Okay, it is also in the Act. 18 subsection 8. What 18 subsection 8 says? It is equivalent to 24(8) of CRPC. What it is? 24(8)? CRPC? 18 subsection 8 proviso equivalent to 24(8) proviso. Every victim has a right to engage a pleader of his or her own choice. Why? Our public prosecutors are here. Who are the public prosecutors? Are you worried about this proviso clause? Why? Public prosecutors, some witnesses, please don't feel offended on me, I am telling about the witness. Some witnesses, they think public prosecutors are not effective in assisting, right? You cannot say public prosecutors are not effective. Everywhere. Some witnesses, they think public prosecutors, and there are some witnesses who will doubt anything, everything also, right? See, it is all people, our own family consists of this and that, no? So, public prosecutors, if the witness thinks or the victim thinks that public prosecutor is not prosecuting the case as expected by that person, he can come to the court and file an application, right? We always tell an old story. Any application filed under 24(8), the judge will say, you come during the stage of arguments. You are all very good judges. You are permitting them during trial. Usually, you file an application for special wakalat whenever there is a government advocate, the public prosecutor. Judges will say, permitted, you can assist the PP at the time of, and you file written arguments. Gone are the days, right? Please read Rekha Murarka versus State of West Bengal. Rekha Murarka versus State of West Bengal, 2011-2019. Rekha Murarka versus State of West Bengal, 2011-2019, Supreme Court. And in this, you can get benefited on 2 or 3 things. What it is, if a victim files an application, along with that you can also, I am sorry for stopping, along with that you can also read another judgment in Aparna Bhatt versus State of MP. Aparna Bhatt versus State of MP, Supreme Court judgment, I think 2019 or 20. Aparna Bhatt, BHATT versus State of MP. Right? Anybody is aware of the fact of Aparna Bhatt? I will talk about Rekha Murarka. First we will finish it. No, Aparna Bhatt is a case where a man like Chandru was wanting to speak to the neighboring opposite house woman, right? Because that is more interesting to speak with our house woman. This man was wanting to speak with the opposite house lady. He was showing all signals. He wants to give some present to her. This lady offended on that. She gave a police complaint. Our judge, what he did, as a punishment, he said, you should go, stand beside her, give some gift and sweets to her, take photographs. This is what this man is longing for. In fact, this man wants to do that. This lady has given a complaint that my modesty is getting outraged. Our judge said, as a punishment, you go and stand with her. You tie some thread, take photos, give her gift. She is rocked, sir, by this. And the Supreme Court was also rocked by this rocking. Supreme Court said, these funny judgments should not be written. Supreme Court said, in any case of sexual violence, abuse, the abuser should never see the victim at any point of time, leave alone bail. Even after pronouncement of judgment, it is protected. So, Aparna Bhatt also please read where Supreme Court says any bail application filed by an accused in a case relating with women, the copies of the bail application should be sent to the victim by the prosecutor and by the police also, and defense also should serve point 1. If she should be permitted to file counter, I am talking about victim participation. And even if bail is granted, you should tell that woman that The dog is unchained now. Right? See, you imagine a woman, you just rape a woman or you assault a woman, how many butterflies will fly on her stomach if she sees that fellow once again? I will tell an example. My judge friend invites me to his house, right? You are inviting me, judge? Definitely. He has a hound or Alsatian dog in his house. Has. So I have also some abilities like Baba Ramdev. But Supreme Court will condemn. He calls me to his house, right? I go near the gate and ring the bell. What he will say, Chandruji, please come. It will not do anything. It stands up to this place. Right? How many anticipations I will have? How many apprehensions I will have? Where it will bite? Right? How it will bite? How much of flesh it will take? But what the judge will say, Chandru sir, please come. It will not do anything. It is true only. It will not do anything to him. Right? It will do everything on me. So it has bitten me. It has bitten me. I went to hospital, all injections, everything. Next week also he is calling me. Just imagine an animal biting a human being for only purpose that he is a stranger. Imagine a woman or a child getting raped inappropriately. It is not only the rape of the body, she is put to shame, right? It is just raping of the soul. If that woman sees the man once again, you just imagine the plight. Imagine Chandru's example of a dog versus Chandru. Even going through that lane, no, that street, or even if judge calls me once again, how many butterflies will fly everywhere? So these are all issues where we should feel sympathetic, empathetic and very sensitive. We should not think that it is someone else's daughter, right? What is the yardstick? If it happens to me, my mother, my sister, my daughter, my sister's daughter, how many butterflies will fly inside? If it is other man's problem, then it is a routine case. If it is our problem, our house people, then it is not a routine case. It becomes an event. Right? So please, judges should have that sort of sensitivity that, see, you people are God. I do not know whether you know that or not. You are all gods in human form. Out of crores of people in Karnataka, God or the system has blessed only few people to deliver justice, man delivering justice for his own men around. Is it not a godly service? It is not a work. You are not paid for the work. It is a great service. One High Court judge, Justice Muthuswamy Iyer of Madras High Court, 130 years, he has addressed judges and said, judges are gods in human form. Judges are gods in human form. Right? And this godly service you cannot do after 60 or 62 or 65. Who knows? I do not know. Right? Either 60 or 62 or 65 or 58. You imagine a day when all the staffs will be around you, nicely take you to the home, okay, with some garland and some ring also. Right? On the next day, you just go and touch your robes or want to put that. Is it possible? If you put that robes once again, your wife will take you to hospital. Which hospital? Because every day she will be telling you don't have this thing. See, there is one interesting thing in every home. If the children know, they commit any mistake, father will say, you are like your mother, mindless. Mother will say, that man is like that, you are also like that. Both brainless. So after retirement, if you go and touch your coat, no, she will definitely send you to that place. So you can do all justice only when law empowers you till that age. Right? You will be hailed as God by people if you are just, honest, sincere, and also having this sweet face. The moment we go to die, sometimes we become very serious. Right? And one good thing by BNSS is, you will not have any people after some time. You will sit like lone lions in the court, deposition centers are somewhere, advocates will be in his home, witnesses will be from somewhere, deposition center, accused will be in jail. So you can be happy. court hall. You can see only court halls. After some times also that court hall also will be removed. Because what is the necessity of court hall when great buildings? Okay. So imagine after 5 years, 10 years and 15 years, how the justice will be delivered. You will not see any ugly faces or beautiful faces of advocates. You will not be irritated and you will not have the chance of physical, nothing. So whenever advocates are around, witnesses are around, for some time you enjoy with them. Have beautiful faces. Right? In this Reka Murarka, the Honorable Supreme Court has said, if a witness has got a grievance of prosecutor not putting sufficient cross-examination or important questions in cross-examinations are missing or witnesses are voluntarily not examined. So any grievance of the victim can be addressed. Aparna Bhatt said it starts from the day of filing bail. Reka Murarka says from even before examination of witnesses. She can say this witness, these questions are pertinent. Public prosecutor has not asked all these questions. And it also says these witnesses were voluntarily left out. Reka Murarka has addressed all these issues that judge should put all the questions. The judge should take questions from the victim and the advocate and it is the duty of the judge to put all those questions if judge feels the questions are relevant and important. Or else now what will happen? It will become a part of record. If a trial judge does not do that, what the High Court and Supreme Court will do? In spite of the fact that the victim has said all these are important questions, relevant questions, it was not done. So victim theory has gained momentum even from Reka Murarka. Please read that also. Okay. Section 19G. 19 subsection 3 is very important. Please remember that 19 relates to assistant public prosecutor. One man speaking here, no water is supplied. Sitting and listening, waters are supplied. This is injustice in the society. I am just joking. Right? Gigi, I will not drink water when I am taking classes. I love you, Ji. I love you. I will also give a kiss after the class. Not kiss. Okay. Section 19. Section 19, subsection 3. What is 19 subsection 3 is, there are many courts without an assistant public prosecutor. Now, 19 subsection 3 says, the judge can inform the district magistrate of the absence and within 14 days notice, the district magistrate shall appoint. So, please use this provision. 19 subsection 3. You can fill the assistant public prosecutors. You will get meritorious assistant public prosecutors if it is done through district magistrates. Then subsection 20. 20 is also very important. It speaks of Directorate of Public Prosecutors. It also speaks of deputy directors. It also speaks of additional directors. So, from 1st July 2024, accountability and transparency will become more because each director in the Directorate of Prosecution, everybody is given an assignment. That deputy should take care of these cases within 10 years, above 10 years, additional director, deputy directors, assistant director of prosecution. So 20 is also very important. Please see 20 also. Then coming to 22 and 23, this has to be read with section 6. We have already seen, right? What is 22? 22 speaks of only session judge, additional session judge, and what are the judgments that the session judge can pass. What are the orders a session judge can pass? What are the sentence they can pass? What is the sentence a session judge can pass? Death, life. Any sentence, including death and life. Okay, what are the sentences a magistrate can pass? 3 years and fine amount is increased for first class magistrate. Do you have a second class magistrate? No. Tamil Nadu also no. Right? Now the magistrates can impose fine amount from 10,000 to 50,000. Okay? 23 subsection 2. Magistrates can pass fine amounts from section 10,000 to 50,000. Okay? Subsection 3 is not important for us because there is no second class magistrates. Then coming to explanation, service, community service, right? I will please read that, kindly take note of that. It is a very easy thing, please don't worry that what is community service is not mentioned, right? 1. Community service shall mean the work which the court may order, community service shall mean the work which the court may order a convict to perform. It is the work which the court orders that man to do. I am repeating, community service shall mean the work which the court may order a convict to perform as a form of punishment for what? For the betterment of that man? No. That benefits the community. So, you should extract some physical work from a fellow instead of that fellow going to mother-in-law's house, right? You see the under trial prisoners coming to the court. You cannot see anybody like Chandru, thinny, bony and weak. Everybody will be like my friend judge, looking very smart, very plumpy, right? Yes, handsome. Yes. See, now the intention of the new law is to also introduce community service, not for all the offences. Please note down section 202. What are the offences for which you can give community sentence, community service? Section 202, section 209, section 226. Please jot it down. 202, 209, 226, 303 part 2, 303 part 2, 356, 355. I am repeating 202, 209, 226, 303 2, 355 and 356 of BNS, that is IPC. But for this I am repeating, but for this, for no offence, you should not impose a community service because that is not the warrant of law. That is not the mandate of law. Okay. I will tell you some example, another one example also in NJA itself. When this one judge asked about this planting of tree, another judge raised his hand. He said, sir, in our place, one judge has ordered for community service. These judges are very advanced in time. Even before community service is coming, they are ordering that, right? One judge, a cow slaughterer. One judge said, you are making this offense of cow slaughtering, that is that man's business, right? This judge now ordered this man to go for a cleansing program of his this thing. Judge has ordered him to go for a Gosala for 15 days. Our judges in NJA said, sir, if you permit this fellow to Gosala, he will select good cows. What for? Yes. That is the reason I am repeating once again. If at all you give any jovial orders like this, then Chandru will definitely see in paper, will go and say that one of my Karnataka friend judges have given an order like that. I am telling you, I have insisted two things. It is the work which the court asks that man to do for the benefit of the community. I am telling, it is not some psychological treatment. It is not asking him to go to attend Sri Sri Ravi Shankar's ashram. Our intention is not to cleanse that man. Our intention is some physical work for the betterment of the community which that man knows and has the ability to do. Suppose if you are convicting me under section 202 and asking me to lift so many and all, no, what is that? Stones. I cannot, I will fall and die. So, why it is not defined? People are worried that community service is not defined. It cannot be because each judge, depending upon that fellow's physique, mental ability, physical ability, topography of the place, geography of the place, so many things plays a factor in that. So, you are the sole judge to decide which work he has to do. For example, a mason comes, you are convicting him. You just seek for some government buildings, there will be work will be going on. Send that fellow for 10 days work and that supervisor should report you. The man who is in charge of that place will come and report, yes, this fellow worked. If he doesn't do the community service, you will recall that, you will give him punishment, he will go to jail once again. Okay? Default in community service sentencing should be, once again you should sentence him. So, two things please underline, work extraction for the, that's all. Please tell your magistrates. Then section 25. Section 25 of BNSS is pari materia with section 31. What section 31 of CRPC? If at all a judge gives a sentence for, see, it says sentences in cases of conviction for several offences on one trial. Previously what you will do, if you don't mention whether all the sentences should run concurrently or what will happen? Previously, if you don't mention, how it will run? Now the judges or now the legislature says, taking into the gravity of the offence, you should definitely say, or else that fellow should not enjoy concurrency. If the offence is very grave, intention of legislature is it should be consecutive. Okay. Overall view of criminal laws is now the sentences are bit harsh. Why means a community should be a place which should be free of offence, and if at all the crime is proved before the court of law, he should be sent to jail. See, I am telling you one thing, this country is a peaceful country, should be a peaceful country. Nobody should be permitted under any pretext of race, religion, language, right? That is all the domain of politicians to take vote. Judges are gods in human form. You don't belong to any religion, any caste, any creed. Even if your father stands in front of you, you should convict that fellow. If at all prosecution proves the case. And evening you can go to jail and meet that fellow as a son. I am seriously talking from my heart. See, Article 21 says right to life and personal liberty, right? What does it say? No person shall be deprived of his right to life and personal liberty except in accordance with the procedure established by law. Take that no, initial no, and except. Strike both. Now tell me. No person shall be deprived of his right to life and personal liberty except in accordance with the procedure established by law. Remove that no, remove that except. Every person shall be deprived of their right and right to life and personal liberty in accordance with procedure established by law. Why it is starting in a negative is, for a caution it has been framed like that. See, Chandru commits an offence, produced before the magistrate, before the judge now, right? She is taking my liberty by remanding me. This is not an act against Article 21. This is in consonance with Article 21. 354 subsection 3 says, if a man has to be given a life sentence, you can give. If you have to give a death sentence, state reasons. This is 354 subsection 3. 354 subsection 5 says, a person imprisoned for death, you hang him till death. This is also in conformity with section 21. 21 says, you deprive right to life and personal liberty in accordance with procedure established by law, because the man was facing a trial and court has come to a conclusion that this is a man who has taken the life of another man. You understand, dear judges? You convict a man not because you are inimical to him. There is nothing called as judge-centric. That is, the judge is a saintly person. The judge sees only the evidence. The judge is not friend or foe of any stupid, right? Judge is a person who doesn't belong to any society. A judge is a good human being with adequate common sense and lot of conscience working in the framework of law. That's all. So, if the judge finds that this fellow has committed a theft, this fellow has caused a grievous injury, this fellow should definitely be sent to jail, whoever it is. If that fellow has not done anything, with all righteousness, we should send that fellow out. There are only two things. So, no judge is an acquittal judge and no judge is a conviction type. See? But your bench clerks, no, they are the certificate givers for you. You know that. Suppose tomorrow I am coming to Bangalore for a murder case. Who is my first guide? You know that. I will come, I will take some Mahatma Gandhi paper and I will show to him. First, that is the visa or passport, right? I will come and I will just stoop with him. I will ask him, Chennakida sir, Uta aita sir, Snana Madhya sir. Some good words to please that fellow. Then I will say, sir, I am coming for a criminal trial. Tell me, sir. what about the judge? Conviction or acquittal? The judge would have come only 1 week before, given one acquittal in a hostile case. This fellow will tell, yes, sir, conviction, acquittal type, sir, you conduct the case, because he knows that whenever I come, I will give some Mahatma Gandhi papers. Right? You should be very careful with these fools around you. He will just subscribe to advocates that this judge is conviction type, this judge is acquittal type. Judge cannot be like that. A judge works on evidence. Okay, dear judges. So, where did we stop? Section 25. If it is a grave or serious offense, please, the punishment should be consecutive. That is what is intention of section 25. Okay. Now, the other provisions are 34G. Please come to 34, subsection 2, Roman 2. Please write 34, subsection 2, Roman 2. This 34, along with 34, please write section 84, 107, 356. 34, subsection 2, Roman 2 should be read with 84, 107 and 356. All speaks about proclaimed offender. Previously, an offence which is punishable for 10 years, you cannot proclaim him as a proclaimed offender. Now 34 subsection 2 Roman 2 explains who is a proclaimed offender. This is the definition. 84 speaks about the process of, you can finish it now itself. 84 speaks about the process of how you declare him as a proclaimed offender. Stages, 84. 107 speaks about attachment of the property of the proclaimed offender, 107. Okay, you can just jot it down, judge, and also mark. 107 speaks about attachment. Now the law says, 107 says, the honorable judges can also pass ex parte attachment order. On the recommendations of the police, if you feel that that property is not attached, if you give notice, then there is a danger of that fellow alienating the property. You first attach it. There will be no harm in making an attachment telling him not alienate. What will be the harm? No harm, right? So 107 prescribes of all these procedures. 356 is an excellent provision, very laudable provision, because there are a lot of cases, in Coimbatore, in Bombay, in many other places, serial bomb blast. What our friend will do? He will have many friends in foreign country. Right? He will kill all innocent people here, all innocent people. See, why the only annoyance of me against terrorists, what these terrorists are capable of? They are capable of bombarding trains, bombarding public toilets, bombarding bus stands, and innocent school children. Are they courageous enough to fight with our military generals? Rarely they do that. Otherwise, whom they are killing? Innocent people. What a man in a public bus stand will know, right? They just do all the serial killings. Where they are? They will be in some foreign countries, like kings they are. And what will not happen? Victim will not even know the judgment of the case, because you can only take evidence in proclaimed offender cases. Previously, you cannot even give the judgment. At least you give a judgment in his absence, the victim will feel, yes, the judge has passed an order of death sentence to them. Now 356 says, like in civil suit, you call the defendant absent and set ex parte. After following the procedures in section 84, you can proceed with an ex parte inquiry, ex parte trial, ex parte judgment. So each stage, you should call them absent and set ex parte. You can finally go along with, even 313 you can ask, with whom you are going to ask. You will say that he has voluntarily absented, right? In every stage you should call him absent and set ex parte and keep moving. At least properties can be attached now totally. At least the victim will feel that courts are not sleeping. One fellow has killed us, and that fellow, if at all he comes to India, they will put him in this thing. And the period which is prescribed for them to set aside those orders are 3 years. Beyond that, we do not know whether Supreme Court will expand it or not. What courts will always say, if he gives a reasonable reason, that is something else for tomorrow, right? So section 34 subsection 2 Roman 2 has to be read with section 84, 107, 356. Okay, dear judges. Yes. No, this is the proclaimed offender. This is accused when they are outside. See, if a witness is interested, no, and witness protection scheme is in section 398. Also note down that every state is duty bound to protect the witness now. It is section 398, witness protection. Are we crossing the time? Yes. Please raise your hands. You are all alert, no? On time. Yes. Yes, section 35. This is very important. Please listen. 35, 1 to 6 is pari materia. Please jot down. 35 subsection 1 to 6 is pari materia of 41 and 41A of CRPC. 35 subsection 1 to 6 is pari materia or equivalent to section 41, 41A of CRPC. Now, 41 speaks about the power of arrest of police. We all know that police people can, or any investigating agency can arrest a person without a, provided the offence is, that's all. Now, second point is very important. This we all know. Arrest is something different from, power of arrest is different from necessity or requirement of arrest. Please write that. You educate your police people. Arrest is not to go and harass and take money. Right? Whenever any Karnataka car comes to Tamil Nadu, my Tamil Nadu traffic police will become very happy. The same is in every state. Right? They will show all their might and right when another state. This is all shame. This is one nation. Right? What a man from Tamil Nadu will think about Karnataka police and what a Karnataka will think about Tamil Nadu police. This is begging. This is not anything. Right? And the only power the police has got is we are fearing that they will arrest. Supreme Court is making a large cry from a long point of time that power to arrest is different from necessity or requirement to arrest. This is where judges should protect the people. The first question by a remanding magistrate to the policeman is, what is the purpose of remanding this fellow? It is not at all mechanical. See? So, Supreme Court, please take the copy of the judgments of Joginder Kumar as a state of UP, 1996, Joginder Kumar was a state of UP, 1996 Supreme Court, Arnesh Kumar was a state of Bihar, 2014. Then Satyender Kumar Antil, Satyender S-A-T-E-N-D-E-R, Satyender Kumar Antil versus CBI, 2021. Then I am repeating, Joginder Kumar as a state of 1996, Arnesh Kumar as a state of Bihar, 2014. Then Satyender Kumar Antil versus CBI, 2021. Then 2022, 2023. Then Mohammad Asfaq Alam as a state of Jharkhand, 2023. Please take a printout. Please take a printout. I have to repeat. Mohammad Asfaq Alam versus state of Jharkhand, 2023. Okay? For the benefit of the judges who are not aware of this, I am telling, a policeman has got a right of arrest. He has got a power of arrest under erstwhile section 41. 41 capital A was introduced under the caption which is called as 41A notice, that if arrest of the person is not required, you should give the summons to that fellow, ask him to come and facilitate the investigation process. That's all, right? So, mechanical arrest and mechanical remand was condemned by the Honorable Supreme Court in Arnesh Kumar. This is in 2000. It was mainly discussing 498, but it said any offence which is punishable below 7 years, you need not put the fellow in that. But our police, no, because one greatest mistake our constitutional fathers have done is Mahatma Gandhi's photo is in the currency. Police people doesn't want money. They want to see Mahatma Gandhi, that's all. That is the reason they are taking money. One nuisance is, you arrest anybody, you threaten anybody, they will give money. See, this is one thing, what the people will think. This is 75 years more than independence, right? How many cases we are filing? Who is filing cases against police people who are taking money? I went to an academy in Coimbatore. It is, one side it is all additional public prosecutor, another side it is DSPs. It was a real grand show. I told them not to record, right? The grievance is, AP police people are telling that APPs are taking monies for approval of, they are telling for 302 10,000, right? For each case, there is a fixed slab. This is the grievance of these DSP boys are fresh boys. They do not know the nitty-gritties, right? They are feeling irritated because the court PCs, SIs are coming and telling that, sir, 15,000 rupees, 20,000 rupees. So, the allegation of the DSPs is that right from FIR till the filing of charge sheet, we are shelling out 20,000 rupees for one case. Okay. These APPs are telling, sir, these police are collecting money from complainant and accused also. This is the justification that they are giving, because police people are taking money from both. See, you go with a case of grievous hurt. You whatever it is, you go with a case of death also, you have to pay. Accused will pay because he is threatened. Complainant will be in he will be in a soup. He will think whether case will be registered or not. So, police is getting from both. And what APPs are doing? To reduce the sin of police, they are taking some money, like putting in a temple. Right? All these are shameless, honorable judges. My question is, these DSPs are telling APPs are taking money. Whether these DSPs are filing cases as against APPs, and the APPs and DSPs are telling, who is more dangerous are the court staffs. That to whom? FIR clerks, then what is that? Other clerks, property clerks, bench clerks. How to come out of all this? How many cases are registered against bench clerks, FIR clerks, man's all this, no? Who would have supported this man? Who is the better half? His wife is his batchmate judge. She is an MP MLA judge now. She is a MP MLA judge of the Madhya Pradesh. Both husband and wife, they are telling that they both spoke with me. I am talking in front of video. They said, Chandru sir, what people will do at the maximum, what they will do? They will kill. That's all. Let that happen. Now that lady told me I am in MP MLA's court. What people will do? Everybody knows we are fighting for justice, and law has given us that power. So still there are people, still there are good people, too good people. That is the reason it is raining always. Okay. Then please take all those judgments. Along with that also read Siddharth was a state of UP, 2021, Siddharth judgment. See, usually some charge sheets are filed under section 170, you know that, 170 CRPC. A case where investigation is not very elongated, usually the traffic cases, no, small cases, prohibition and traffic 170. Cases of those nature, police need not arrest and bail is not mandatory. This is what is said in Siddharth was a state of UP 2021. Okay. Then 35 subsection 7 is a new law. 35 subsection 7. What it says? 35 subsection 7. I will read from second line. It is easy for understanding. What 35 subsection 7 says, in case of an offence which is punishable for imprisonment of less than 3 years, see, it should be an offence which is punishable for less than 3 years, and such person is infirm, irrespective of age, or is above 60 years of age. Come to the first line. No arrest shall be made without prior permission of an officer not below the rank of DSP. This is one new inclusion. So, remanding magistrates should be very careful if a man who comes with an FIR, if an accused who comes with an FIR for remanding, the offence is punishable less than 3 years, and he is an infirm man like me, or he is an aged man and also 60 years of old. Okay? So, this you should be very careful. 35 subsection 7, please note it. Then 36 and 37 read together. 36 and 37 read together. Now, a designated officer will be appointed by every state, and it is the duty of the designated office of all the police stations to inform about all the arrest. Previously, when a policeman arrests a person, God only knows where that man is, because they will not keep in the very same police station, right? Even guards will not be knowing, policemen will be knowing that better, right? It is not the duty of guards to search for all this. So, whenever a policeman arrests a person, now 36 and 37 says, there shall be a designated officer who should be arrested about all the details, right? Who should be detailed about, and that designated officer should display in his office with regard to who is arrested, in which station he is, where it is kept, all the details for all offences, right? This is section 37. 40. Now, private arrest is also there. Any man who does a private arrest, now what he should do, within 6 hours of arrest, he shall hand over to the police. 6 hours. Previously, no time limit was mentioned. Now, the time limit is 6 hours. Then, previously the word used is, if the man after arrest hand over to the police, police should re-arrest. Now, police will take custody, because arrest was already made by way of a private person, and 6 hours time is provided. See, this is all expandable. If that man comes and says why he cannot hand it over within 6 hours, if he says some reasons, it is reasonable, should record that and write, that's all. Or, using this, the man in custody will file a case as against the man who executed the private arrest, that beyond 6 hours it becomes he will go to National Human Rights Commission, that's all. It will facilitate advocates to earn there also. Then 43 subsection 3. From 1st July 2024, we will see accused with handcuffs in the corridors of the court itself, right? Previously, magistrates were given the power to decide whether the accused should be in handcuff or not, right? I don't think this is too fair a law. Right. This is talking from the side of a humanitarian lawyer. All policemen will be happy on this, because for them, if they handcuff a person, they will be scot-free. They need not have the pain of just monitoring them. Policemen will be very happy. Now, set of offences were given for which handcuffs should be put. Now, you write some 2 or 3 judgments. What is the famous judgment? Sunil Batra. Sunil Batra versus Delhi administration, 1979 and 78. Sunil Batra versus Delhi administration, 1978, 1979. 2 judgments of the Supreme Court. Then Prem Shankar Shukla versus Delhi administration, 1980 Supreme Court. Then Prem Shankar Shukla versus Delhi administration, 1980. Sunil Batra versus Delhi administration, 1978 and 79. Then Citizens for Democracy versus State of Assam, 1995. Citizens for Democracy versus State of Assam, 1995. These 4 judgments run contrary to our present section 43 subsection 3. These 4 sections, I want to repeat. Sunil Batra versus Delhi administration, 78-79. Then Prem Shankar Shukla versus Delhi administration, 1980. Then Citizens for Democracy versus State of Assam, 1995. These 4 judgments said police should not. These 4 judgments said if at all police should put a man in a handcuff, magisterial permission is essential. Magistrate should apply the mind and see 2 things. One is whether this man is a danger unto himself. Because there are some accused, what they will do, they will hit their own self. They will put the head down, they will dash against something, right? So, if a man has to be handcuffed, police will show that he is a dangerous person for himself or dangerous to others. Second is, he has got a propensity to escape from custody. These 3 were the yardsticks for putting a man in fetters, iron fetters. Now, unfortunately, legislature says, taking into consideration the nature and gravity of offence. See, nature and gravity of offence doesn't have anything to do a man with handcuff. For example, it says if a man has raped, if a man has committed a murder. See, murders, private murders are there. Suppose my neighbor is irritating every day. After killing that fellow, this fellow will become remorseful. Why I did that? This fellow will feel remorseful, he will feel very weak. Like that, no rape cases. After that, it is all harmonical imbalance. After that hormonal imbalance, this fellow will remorse. Why is that I did? He will, and putting that man in fetters, no, and making him to put more shame every day, right? So, putting a man in iron fetters, the yardstick of nature and gravity of offence is not a true yardstick. However, now common man will understand that if a man is an iron fetter, a common man will understand that this fellow has committed a serious offence. That shame should not be, because the second question, if it ends in an acquittal after 5 years or 10 years, can we compensate that man the shame which he has underwent? And all the offences which the police registers, complainant gives, cannot also be presumed as true. So, I think that some constitutional, perhaps Karnataka court also may struck it down. Anji. That is what I am telling. Gee, that is what I am telling. Now they have given a list. They are telling that taking into consideration nature and gravity, they have given a list. So, either the police or the court do not have any say in that. You should see the FIR. If it has to be arrested, then you should do that. My question is, you cannot presume that all the informations are true, right? And it will end only in conviction. If you put a man in fetter for 10 years in court, after 11th year you say prosecution has not proved the case, what is the shame he undergoes out of that? So, perhaps 43 subsection 3 may be struck off because of the judgments of the Honorable Supreme Court already, right? Now, whether this 43.3 is legal or not, morning I have said this is a law of the land. And presumption is, legislature is aware of all the Supreme Court judgments. In spite of that, by march of law, it has designed this. Okay? Yes. 43. Okay. Then 48. Obligation of person making arrest to inform about arrest, etc., to relative or friend. In this also, designated officer is there. Besides informing the relatives and friend, designated officers has also to be informed. Now, section 50, only a small addition is made. Second line, immediately after the arrest is made. Seizure of weapons, offensive weapons has to be made immediately. This is the inclusion in section 50. Then 51, 52, 53. We will finish these 3 provisions and we will wind up for lunch. Before coming into section 51, 52, 53, you write some 3 or 4 judgments which are very important. Krishan Kumar Malik, Krishan, K-R-I-S-H-N, Krishan Kumar Malik, M-A-L-I-K versus State of Haryana. 2011. Krishan Kumar Malik was a state of Haryana, 2011. Rajendra Prahalad Vasnik. Rajendra Prahalad Vasnik was a state of Maharashtra. 2018. Rajendra Prahalad Vasnik was a state of Maharashtra, 2018. Then Chodkau versus state of UP. Chodkau, Chotkau. Chodkau versus state of UP, 2022. Munna Pandey versus state of Bihar, 2023. Munna Pandey versus state of Bihar, 2023. And another judgment is Ravi versus state of Maharashtra, 2019. Ravi versus state of Maharashtra, 2019. Beside Ravi, you write it, DNA results are scientific in nature and reliable to an extent of 100%. Besides Ravi judgment, you write DNA, results of DNA are scientific in nature and reliable to an extent of 100%. Supreme Court in Ravi versus state of Maharashtra, please read that judgment. Supreme Court has explained the credibility of DNA examinations and the results thereof. It doesn't mean that only with DNA result alone you can convict a man. But reliability, because it is a 100% scientific evidence, it is reliable to an extent of 100%. Okay, I will tell you a small story. I know that it is all, you are all hungry. Right, one girl, 8 years old. You know Kothkai rape case? Kothkai rape case. Kothkai, 2017, Himachal Pradesh. I will give that district judge's judgment to our Satish ji. Please read that Kothkai, Kothkai, Kothkai rape case. 2017, in a forest in Himachal Pradesh, Shimla, forest name is Hailela. In Hailela forest, this school girl, 8th standard studying girl, after the school, she was returning to the home. And if at all you are adapted to the villages and forest areas, children will not walk on the main roads. They know some little this thing. No, she's a small child. She will not know that a human being like that will follow. Right? I will not call that man as an animal. Please don't term any man like that as an animal, because paper says animalistic act by a man. No animal will do that. Right? No animal will take a towel and follow the female animal and put it in the mouth. Right? And no gang rapes are also there in animal kingdom. And no animal will put its hand or feet inside the sexual place. Right? We are capable of doing all divinely act and all demonly act. So you please don't term any rapist as an animal. You don't degrade animals. Right? This is a case where the child was followed, smothered, and the trick of these people, the committing rape, they smother the child or woman first. Why? Excellent judge. Please give a clap for her. Excellent. Who worries whether she cries or not? To avoid resistance. They are so lazy that they don't want to fight and rape. I am telling you one thing. Take idiotic husband or wife in the house. Idiotic. Who will be troublesome wife, troublesome husband? Lazy people. Every crime, every problems you can connect with laziness. You cannot find in matrimonial cases also a man busy like you fighting with his wife for divorce. Rarely only a non-lazy man will come to court. Any man who is tightly packed with work, norms like you. Suppose if High Court doesn't takes the norms off, you will also start more fighting with the wife. Thank God norms are there. See, every lazy man will do some crime. And this lazy fool, he smothered it, he just turned the head of the child, raped the child and left off. Right? It became a big news. Shimla is a tourism place. It became a great news in all the TVs. Immediately what the DGP did, he went for a camp office there. What will happen? Our police knows both astrology and astronomy. You know that? Their investigation is only out of their gut feeling. They know Chandru will do this. Raman will do this. Things are not scientific. They immediately, because DGP came, they should tell the public, no, we have arrested. Beautifully, they have arrested some 6 innocent persons. Innocent persons. They would have been tall, black, and ugly. Man very, like wheatish, white color, having all this will not do anything. This is our expectation, right? They arrested 6, thrashed all the 6, 1 died. Custodial violence. Immediately what has happened? The rape and murder become a small issue. Killing of a tribal person become a big thing. Then DGP ran out of that place, said CBI will follow. CBI came, collected the swab from the girl, and that swab was dissected. Swab is the secretion in the vaginal portion. Collected that, dissected that, and made an analysis called as YSTR analysis. That is, Y denotes the male chromosomes. Because if I commit a rape on a woman, my chromosome sperms are also there, and her secretions are also there. So a dissection was made under the caption called as YSTR analysis, and they had the DNA material matched with all the 6, 0. Right? Materials collected from the child doesn't match even to an extent of 0.001 with all the 6, including the man who died. Then the original FIR was scrapped. CBI put another one FIR. Now they are having a DNA material with their hands. They went on around the village and took the samples of many people. Out of 400 samples, 1 man was caught, but that chromosome was not matching 100% with the 6 they were released, sir. See, they are already having YSTR analysis, male chromosome, they are having male sperm they are having. They have taken a DNA material with them. And out of 400 people they have examined, 1 man has got 25% matching with this. That means 1 family member of this man has committed. Okay. Then what they did, they called this fellow, they investigated him and put a family tree. Now CBI and forensic should make a lineal DNA search. Right? Then they called everybody, searched, none matched. Then out of the blue, 1 man said, we have got 1 relative, he will rarely come to this place, he is a woodcutter, previously also he has done some offense. Where he is? No, he is not connected by anything, sometimes he will call us. And after 1 or 2 months, this fellow called 1 relative, CBI just traced that, nabbed that fellow, matched it 100%. Now imagine, had this 1 man not died, what will happen? Police will project this 6 in all the photos, right? 27 Evidence Act is there. We will believe that 1 panties of the girl and panties of the boy, 1 or 2 this thing, they will say that we statement disclosed, it led to discovery of all this. These 6 fellows would have died by then because it is a media trial, we will put all of them in this thing. So now BNSS is insisting for any offense which is punishable, 176(3) of BNSS says, for any offense which is punishable more than 7 years, DNA is mandatory. Okay, we will resume the class after post lunch. I love you all. Bluffing is very easy. Attending for that very patiently is very difficult. So I love you all. Thank you so much. 176 subsection 3.
Welcome you all back to post-lunch session. I request Shri E.V. Chandru sir to continue the session.
Good afternoon, judges. Oh, which is the provision we left? 55? 51, 52, 53. Okay. Yes. Okay, we'll start. Yes. Are you all happy after eating? Yes. What was very special in today's food? Is sambar special, madam? No, dosa idli. Jalebi. Okay. You had vegetarian or non-vegetarian? Oh, no non-vegetarian food. Okay. Before lunch, we were discussing about section 51, 52, 53 of BNSS. Okay. In BNSS, one of the main features of the present DNS is forensic evidence, DNA analysis, using mobile phone for audio, video, electronic means. Apart from that, every stakeholder will have a time frame, including judges, right? These are the main features of the present BNSS. 51, 52, 53 has to be read with section 184 of BNSS. 184 relates to section 164 of CRPC. That is, examination, 184 speaks about examination of a rape victim. 51 speaks about examination of an accused on request of police. 51. Medical examination of accused on the request of police officer. This is 51. 52 speaks about 52 speaks about examination of a rape accused in specific. 52 speaks about examination of a rape accused. 53 speaks about medical examination of the accused. 51 is on request of police. 52 rape accused examination. 53 speaks of medical examination. It also 53 speaks of one more examination. That is, if the court wants or any other authority wants, that fellow has to be examined once again. One more examination was also provided. Okay. These are all stated in 51, 52, 53, read with 184, which is in relation with examination of rape victim. Now, my question to the learned judges is, in a case of sexual violence, a penetrative assault or an insertion, right? Examination of the victim is more important or the accused is important? Which is more important? Victim. This will be the common answer. Both is the right answer because there are two types of, in a rape, if it is done by the male organ, it is called as what sex? Penetration. If it is done by penis, it is called as penetration. Insertion is by any other object. Okay? Because it is starting in PEP, you understand that in this thing, right? Invariably, in all the medical papers where the woman was penetrated by a man in a rape, you will see doctors writing as toe-lock injury, That is a tear in the upper portion of the vaginal portion, right? 12:30 injury, 6 o'clock injury, 3 o'clock injury, all this denotes the tear in the vaginal portion. Now, medical science believes, and the Supreme Court also says, if a man could penetrate and tear this much, what should be seen in the accused? Reciprocal injury. In that score, examination of this fellow is very, 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 very imminent and important. To fix two things. From the morning I am telling two things. That an innocent should never be punished. And a real culprit or a guilty should definitely be sent inside. Because such a person doesn't have any place in the civilized society. Okay. It is the expectation that reciprocal injuries should be taken note of immediately. Because if you arrest that fellow and send him to medical examination after 3-4 days, what will happen? What will happen? Injuries will get, that too for small boys within 25-30, injuries will get cured within 2 or 3 days. And apart from that, it will be healed. Apart from that, the DNA materials or the secretions from this poor girl, saliva, bite mark, nail markings. See, nail markings depends upon the fragility of the girl. Suppose you smother a girl, she cannot put nail marks like a tiger. Right? Even if it is a small child, no. That child may try to bite, that child may try to do something. You cannot catch one ant like that. Even an ant will resist. So, in any sexual violence, that is the reason morning I said, these lazy fools will first what they will do, they will smother and put them in an asphyxial state because they are not worried about human beings. The conduct of them is not love at all. It is something erratic. See the case of that small girl who died in Delhi. Nirbhaya, you just read the judgment, right? And see, that small child, 20 years old child, the injuries are from navel till anus. A open injury from navel till anus. What is the extent of injury? Almost the entire stomach is torn because these 5 to 6 fellows, they want to do a penetrative assault. Science says if you are drunk, no, penetration is not very effective or possible because alcohol in the body will make the blood vessels dilate. Right? It will not make the blood vessels contract. Penetration is a process where pumping of blood should be too much for penetration. But they have went with an intention to penetrate. When they fail in doing that, they could not do that. They saw for some other object. They had hand with them. And they also had a large pipe, which is used to tight that this thing. So this is the human mind. They want to do something. They cannot do their organ. They did something. They took the uterus of the child out. Right? In this core from the morning I am telling parentage is very important. Responsible children will come out, responsible people will come out only by responsible parentage and good neighborhood. Right? Now 51, 52, 53, it speaks of examination of the accused because this accused will also have so many matters and materials in connection with the offense which he has committed as against the other person. In a fight also, if 2 persons fights, he gives an injury, they also give an injury. It will explain and establish the presence of the man in that place, point 1. 2 is, this reciprocal injury, this man is now answerable. He should say, under section 106 of Evidence Act, this fellow should explain how he has sustained an injury at this point of time when a girl has said it is because of this act. And all other materials like hair, pubic hair, secretions of the girl, saliva of the girl, so many DNA materials he would have carried in his body. So, protecting that in order, see this is for the welfare of the criminal justice system, I am telling. I am not talking that everybody should be put to jail. If this fellow is the real culprit, he will carry so many materials, examination of him immediately will render real justice. So, please advise the people down the line and also the stakeholders that the common knowledge or the common belief that the victim should be immediately examined, equally important is this fellow also because he also proves the case. Okay, this is one thing. Coming to We saw 4 judgments in the morning. I dictated 4 judgments. One is Krishan Kumar Malik versus State of Haryana. Another is Rajendra Prahlad Vasnik. Third is Chotka versus UP. Fourth is Munna Pandey's case. Hey, this Krishan Kumar Malik case, anybody has got a phone with you and a net also? Just type the judgment, Krishan Kumar Malik, in Google. Krishan Kumar Malik was a State of Haryana. It will not work here. Okay, I will tell. In Krishan Kumar Malik, why I wanted you to see that is, Supreme Court has said, it is the mandate of CRPC, section 53 small a, CRPC 53 small a, and now it is 50, 51, 52, 53, that medical examination means, small a, examination means examination of sperm, swab, sputum, saliva, hair, then nail clippings, and any other DNA examination. This was introduced in 2005. Krishan Kumar Malik, Supreme Court said, why is that prosecution and investigating agency are failing to take DNA evidence and send it for forensic examination? Now it has become a mandate of law as per section 176 subsection 3 of BNSS that any offence that will be punishable more than 7 years, it shall do that. And policeman cannot escape saying that no, DNA facilities, forensic is not available. It goes to the extent of saying in the proviso that state government should publish, notify that if I do not have such a facility, I am referring this to the other state. So please, as judges remanding, remand judges should definitely, it is the duty of us to see to that culprits need not escape and innocent accused also doesn't suffer, and victim should be protected, right? Please think about the plight of a victim who believes that, see, there are 2 persons who are key persons in a court of law, in a criminal justice system. One is an accused, another is a victim. An accused is a man who says to you that his right to life and personal liberty has to be protected. No doubt it has to be protected. Victim is a person who has already lost his right to life and personal liberty. Either the victim died, so legal heirs will be anticipating some good will be done by these gods, right? Next is a man who would have lost his limb, eye, suffered something. He is a person who believes in the system much. How? He just goes and gives a complaint, rest assured in his house, thinking that state is taking care of me and judges are taking care of me. This investigating agency should be sensitive enough, prosecutor should be duty enough, and judges should also be godly to see that justice is done. Okay, this is a man, victim is a person who sits in his house believing that the country is taking care of me. Such belief has to be protected. Okay, in Krishan Kumar Malik, Supreme Court referring to, sir, you have got it, sir. Please go to find and put sperm, SPRM. Go to find. In that, go to find and put sperm. Okay, you just search it. My question is, in a rape victim, right, after the door, and even if maintenance petitions are kept for years together, just imagine a situation where I said I have got a good parents. Imagine a scenario where my mother was begging in the court when I am studying 1st or 2nd standard, right? And also imagine a judge sleeping over a maintenance petition for 5 to 6 years or 10 years. What would have happened to my mother's life and the education of the child? Can you have a Chandra or can you have so many judges here? If our parents had been to a maintenance court and maintenance was not given by the judge, we are, see, in fact, if maintenance is not given, no, 2 or 3 generations will get spoiled. Just imagine, if they don't have anything to eat, how the woman will send the child for school. So please take maintenance issues as very, very serious. Right? What are the 2 things to be seen? Whether marriage is disputed or not, whether that man has adequate resource to pay. Adequate means he should not be like, he need not be like Ambani. He will be having something, he is potent enough to have a daring decision to marry. He has also married, procreated children. Now who will take care of that? So maintenance petitions are very, very serious. too serious. I am using the word that the woman or the father begs with you for money. They are literally begging without a plate in their hand. They are begging. So all dilatory tactics of the other side has to be curbed only by the honorable judges. If I appear for the husband also, what I will do? I will advise him, we will prolong the matter. Once the husband senses that this cannot be prolonged in this court, he will definitely give. It is all the signal which the judge should give. If a judge says all these dramas is not permissible here, he will definitely give. In so many cases, he will throw out one wife and small children. He would have married a second woman. What is the counter they will file? No, presently I am married, having children through her. I have to take care of my second wife and children and also my parents. See, by giving not maintenance, I am repeating, a second, third generation will get spoiled. So, this is a welcome move. Section 145 says, old parents need not go where that fellow is. They can get maintenance from their place itself, right? This is a good move. Section 148. Okay, I have to ask one sensitive question. Which gender is very powerful? Very delicate question. But I want all of you to raise the hands. Which gender is very powerful, male or woman? How many of you say woman? Please raise. So you are all surrendering to woman. Accepting the fact. Oh my God, please give a good clap for sir. Accepting the fact. See, any civilized society, if it doesn't respect a woman, I am repeating, any civilized society without respect to women, that society will never progress. Right? Women should be respected and worshipped because they have a special ability over and above the man to procreate a child, have it there for 12 months, which is very difficult. Very difficult, 10 months, very difficult. You go for a feast, eat nicely 1 or 2 plates of biryani. I am talking about my male friends. Okay, you eat a full meal and drink also ice water 1 glass and see whether you can walk, you can sleep, you can lay down on the face. Very, very difficult. They all had us in their stomach for 10 months. They have given all, I told in the morning, all of you are looking beautiful with lovely eyes. Your fathers would have contributed, but who is the builder of this? Your fathers are only investors, right? So please respect women. Women should be respected more and they should be worshipped, right? I went to Guwahati. Interesting story. They took me for a ride in the cruise. I asked them, what is the river? They said, Brahmaputra. Then immediately the man who explained said, this is the only river which is not worshipped. I asked him, why? Male river. It is not Putri. Brahmaputra. Right? Then he added one thing more. Because it is not worshipped, this will become very wild often. Brahmaputra is very dangerous. People there in Guwahati told me it is very dangerous. It becomes very wild. It is not Ganga Ma. It is Brahmaputra. Right? Okay. For 148, I have to say so many stories. Section 148, previously for dispersal of unlawful assemblies, only male members were used. Now dispersal of unlawful assemblies, any person word was used. I told this in one academy. One judge in a lighter sense said, yes, women are capable of not dispersing assemblies, families also. But I don't accept that. Okay. So dispersal of assembly, now any person means NALSA versus Union of India, all the 3 genders are equal. So any person would include male, female and third gender also. Okay. Section 139. What are the 149? Use of armed forces to disperse assembly. That is, 2 words were added. District magistrate shall be dispersed by a district magistrate or any other executive magistrate. Okay. That is the one addition. Section 152, conditional order for removal of nuisance. That is 152 subsection C. 152 subsection C is an addition that the construction of any building or the disposal of any substance is likely to cause conflagration or explosion should be prevented or stopped. Now, if at all there is a public nuisance by way of any construction, previously we will go only to a civil court for an injunction. Now 152 says, subsection C says, one subsection C says, a magistrate is empowered to remove the construction if it is a nuisance, or he can stop that also. You should read that with 152 subsection 1 I Roman 3. 152 subsection 1 I Roman 3, to prevent or stop the construction of such building or to alter the disposal of such substance. Okay. Then 154, this has to be read with section 530. What is 530 once again? Yes, it is not that courts alone will do audio video hearing, even magistrates also, executive magistrates also can do that. Okay. 154 subsection, not a subsection, it is 154B. Hearing may be permitted through audio video conferencing, may be permitted. Okay. Okay. One request to the judges, or if now law provides for audio video hearing, from 1st July, you please encourage, if advocates comes to court, you please encourage them, please be in the home and addresses. Why? Firstly, there will not be problem in the court. Secondly, there may be some problem in the house if he keeps on sitting, right? That woman will keep driving him out, because the only relief of a woman in the house is this man's absence. Or the vice versa. This is all genderless words, man and woman, right? Third is, pollution will be less in the street. Pollution will be less in the court also. Okay. See, honorable judges, I am telling you very seriously, when science and law gives us some provisions, we should not feel egoistic that when a man appears in video conferencing, judges, many judges, they should not think, I am sitting in the court, I am coming all the way in metro and bus with all difficulties, you will sit in this thing. Especially when injunctions are argued, no. We will appear in audio video as an advocate, I will also appear in audio video. For what cases I will appear? Normal cases. Suppose I have to have an injunction or an extraordinary relief, what I am also thinking, I should go personally and show my face to judge. Madam, you are a good person.
Insist, no, they used to tell us, no, like personally, if you come, it is better always.
Madam, you are right. She is absolutely right. Because some courts, they are asking advocates, will you not come? You sit there. See, advocate is a person who is worried of his existence, survival, and he is also worried of the relief that he has promised some man to be done. So he cannot afford to sit there. My common prayer is, when law says something, if uniformly all the judges say, sir, law provides you this thing, leverage, please undertake that, then it will happen. All this, madam, we are in a transition stage. All this will take place. It will take some time. Our next generation, even if you call, will not come. You leave this old man like me, 40, 50. Just a law college boy comes out of the college. He will read this provision and he will read it to you. See, generation has changed. No, people, now children are not listening to whatever elders says. So all will come. Then it is section 157. Proceedings, I told you all the stakeholders are bound by time frame. 157 says, it is proceeding to be completed within 90 days, which may be extendable up to 120 days. So it is time frame now. Then 162 has to be read with section 15. In the morning I said 162 should be read with 15. Executive magistrates, right? a district magistrate 162 or subdivisional magistrate or any other executive magistrate or deputy commissioner of police empowered by the state government of the district magistrate in this behalf may order a person not to repeat or continue a public nuisance. Okay? It is for prohibiting or not repeating a public nuisance. This is in section 162. Right. Now, next chapter 12, 168 to 171. Chapter 12, section 168 to section 171. What does it say? It says preventive action of the police. Earlier in CRPC also, from 149 to 152, all this was there. Right? One addition to this is section 172. What is 172? Persons bound to conform to lawful direction of police. This was not in earlier CRPC. Earlier CRPC gives the power to the police to prevent actions which are which may lead to cognizable offences, right? Preventive action of the police. Now it says, in executing these provisions, 168 to 171, police may pass an order. And any person who doesn't conform to that order, FIR may be registered as against that person for not listening to that orders. It becomes a cognizable offence. Okay, this is one addition, 172. Now we are coming to real BNSS. Section is 173, equivalent to 154. Okay. Now it is the real fun starts from here. What is 173? 173 is 154.1. We will just understand what is 154 for 1 minute. Okay. What is 154 of CRPC? 154 subsection 1 is important. Subsection 2 is also important. 3 is also important. This 154 subsection 1 says, every information relating to a cognizable offence, if given orally, shall be reduced into writing and by the station house officer and to be read over to the informant and to be registered in a book called as FIR book. This is 154.1. This is reflected in 173 subsection 1, not verbatim, with some changes. Right? 154 subsection 1 was interpreted by the Honorable Supreme Court in Lalita Kumari versus Government of UP 2013. Lalita Kumari versus Government of UP 2013. Same judgment, Lalita Kumari versus Government of UP 2014, another one judgment was there. Right. Question before the Honorable Supreme Court in Lalita Kumari was, what are the options before a police officer if an information regarding cognizable offence is given to him? Before Lalita Kumari, certain police people, they used to make an inquiry called as preliminary inquiry. Constitutional bench of Supreme Court said 154 subsection 1 starts with the word every. Suppose our Honorable Director tells you after the session is over, everybody should come to my chamber. Who cannot come? Who need not come? Except Chandru. Shama, beautiful answer, sir. Give him a clap, Ji. No, this clap is not Kannadiga's clap. Yes. Ji, how do you think like this? Okay, forget Chandru. Okay, everybody should come. Who can abstain? Nobody. Director is coming and telling, anybody can come. How many of you can be there? Either all or no one. See, just 2 words. Only Chandru. Because Chandru has to be until tomorrow. See, this one word, every information led to a judgment of a constitutional bench, 5 judges stating that you don't have any business or authority to not register an FIR when FIR is given. You cannot disseminate or dissect and see that this is a false information, this is a true information, this is worthy, this is non-worthy, nothing can be done. This was said by the Honorable Supreme Court 5 judges bench in 2013. In this judgment, 5 exceptions were given. 2M and 3C. What is this 2M? Medical, negligence, matrimonial cases, then commercial disputes, then Prevention of Corruption Act, then cognizable offences with a delay of 3 months. These 5 exceptions were given, and Supreme Court said for all these 5 cases, you can make a preliminary inquiry within a period of 7 days to understand whether it discloses a cognizable offence or not. This was laid down in Lalita Kumari in 2013. Then the government went and filed a CRMP, miscellaneous petition, and said 7 days time is a very too little time, so you expand it. Then in 2014, it was expanded as 15 days. So this is Lalita Kumari, right? What it is? 154 subsection 1 is mandatory. Point 1. Violation of 154 subsection 1 will lead to contempt of court. Point 2. Where contempt of court has to be filed? At any high courts where the party resides. 3 years, it becomes an offence under section 166 IPC. Please listen very carefully. Now we are coming to a place where in present BNSS, so many time frames were given. So many new orders were given. Whether they are all mandatory, whether they are all discretionary, whether they should be taken as may, whether that may has to be taken as shall, or shall can be considered as may. Now I have to deliberate on this portion first. People in Tamil Nadu fight for their rights so much. You all know that? Yes. Any new law comes, we will be the first to go to the Supreme Court and come back with no guarantee of result, right? When I was a very small boy, 2002, I enrolled in 1997. If there is a strike, I am also an ordinary person. If there is a strike, it gives some happiness, because we are all basically from school have seen good strikes. So if that continues in bar also, you will feel happy, right? 1999 saw greater changes in CPC. 2002 also changes, amendments. Salem Advocates Bar Association case versus Union of India. We all went to the Supreme Court with a fond belief that judges will say that amendments are invalid. Supreme Court full bench said all amendments are perfectly valid. Now also somebody will go. Result may be like this only, right? In that, what has happened, section 148 of CPC read with order 8 rule 1. What does it say? Return statement shall be filed, a return statement shall be filed, underline the word shall be filed within a period of 30 days. Court may extend it for a period of 90 days. 90 days. So total it is 120 days, right? 30 and 90. Now, question before the Supreme Court is, we are taught in law colleges, word shall means shall only. It is mandatory. Word may means directory. But Supreme Court says word may be shall in some cases. Right? CBI versus Master Bolu, 2021. Write this judgment, CBI versus Master Bolu. BHOLU, Supreme Court, full bench. CBI versus Master Bolu, Supreme Court, full bench. It says, Supreme Court says, word may is not always may. Word may will also become shall. What has happened in this Master Bolu's case, interpreting section 15 subsection 1 of the Juvenile Justice Act. What is 15 subsection 1 of JJ Act? Preliminary assessment. In whenever a small child commits a heinous offense, he will be subjected to an assessment called as preliminary assessment to see whether the child is aware of the act which is committing, whether he is physically capable, mentally capable, and whether he is aware of the consequences. Firstly, a child which is of the age of 16 to 18, which commits a heinous offense, will be put into an assessment called as a preliminary assessment under section 15(1) of Juvenile Justice Act. In that, they use one word, that a psychologist may be in the assessment group. The may be a psychologist. Now, it went up to Supreme Court. This is a case where a second standard boy died in a toilet of the school. His throat was slit. The child bleeded and died. Immediately, who will be the scapegoat in this country? For murder, principal will not be there. Sweeper, excellent sir, you are the true person sir. Sweepers, drivers, see those sweeper drivers are very godly sometimes, many times. They have all taken care of us nicely, right? Immediately that sweeper and driver, sir has rightly said, they were all arrested, thrashed severely, and finally a 11th standard boy was suspected, and that boy unfortunately was very tall, black and stout, disproportionate to his age. Assessment board says, no, he is looking very huge. So, he will be tried as an adult. See, from the morning, I am putting it in a funny way, but just look into the sensitivity of us. This goes up to the Supreme Court. Supreme Court said, what is this assessment? And the word may have a psychologist should be seen in the social context of the implication that will have on the society. Suppose a psychologist is not there, because what we will think, may have a psychologist, it is only discretionary. One boy's life is going to have a U-turn. This small child will be put to a session judge. Session judge also may get carried, because already the team has said, he is stout, he is looking like an adult, he is understanding everything. So Supreme Court said, this word may in 15 subsection 1 should be read as shall. This is one thing. Our Bar Association case, same Supreme Court, 2005 said, this word shall should be read as may, because in CPC, they have said that return statement shall be filed within 30 days, extendable up to 90 days, but no consequence is provided. Even though the word shall is used in any law, if consequence is not said, then shall will become may. One another judgment in Mukherjee versus Mukherjee, Division Bench, Calcutta High Court. Okay, you should write it as Mukherjee, M-O-O-K-E-R. Mukherjee versus Mukherjee. Calcutta Division Bench High Court. It is with relation to section 14, subsection 1 of Hindu Marriage Act. What is 14, subsection 1 of the Hindu Marriage Act? Excellent, madam. Yes. One man or a woman got married. Immediately after getting married, he has a wisdom also. I have done a wrong thing, I have to come out. 14:1 said, gate is closed. It is closed. You should suffer at least for 1 year. Okay. No application shall be entertained by a court of law for a dissolution within 1 year from the date of marriage, except in circumstances where they prove exceptional depravity and hardship. This word is there. This went up to Calcutta High Court. Now Supreme Court has also said. Now what they are telling is, the word shall does not have any other punishment clause or consequence clause. Any consequences, no consequences. So in any law, whenever a word shall is used, if no consequence is used in the subsequent sections, then it becomes, shall becomes may. Now come to Lalita Kumari. Section 154 says, every information relating to a cognizable offense, if given orally, shall be reduced into writing, read over to the informant. That's all. 154.2 says you give a copy. 154.3 says something else, you write it to the SP of police. Where is the consequence? Supreme Court but said in Lalita Kumari that you fall on section 166 IPC. What IPC 166 says? Any man who is in disobedience of law should be punishable. If you apply this yardstick to present BNSS, all shall will become shall only. See, I am repeating 154 subsection 1 of CRPC, where the word shall for registration of FIR is used, do not have any inbuilt consequences in that law itself. It doesn't say send the policeman for violation to jail. Supreme Court take refuge from 166 IPC, which says a man who is disobedient of any law should be punished. Supreme Court said 150, all CRPC laws are law. If you don't obey that, it is punishable. Now Supreme Court, see, now in CBI versus Master Bolu, they said social intention has to be seen, social repercussions has to be seen. Now if you permit policemen, you no, it is all only mandate, not mandatory, it is only discretionary, you don't file FIRs. What will happen? Great anarchy will happen, injustice will happen because of delay. What we will write in the judgment? We will write one word, beautiful word. The lodging of FIR is with an inordinate and unexplained delay, and hence the prosecution has also not proved the case beyond reasonable doubt. Accused is always presumed to be innocent. He looks like a saint. We will send him to house instead of mother-in-law's house. Right? So, the Honorable Supreme Court, this is one thing. I will tell you the latest judgment, Messrs. SCG Construction Infrastructure Private Limited, M/S, Messrs. SCG Construction Infrastructure Private Limited versus Chamankar. Messrs. SCG Construction Infrastructure Private Limited versus Chamankar, 2019 Supreme Court. Now, Order 8, Rule 10. What is Order 8, Rule 10? Commercial Code. Commercial Codes. Order 8, Rule 10, Amendment Act in CPC with regard to Commercial Code Act, it said return statement should be filed within 120 days. Our people went to Supreme Court, thinking that Supreme Court will say, no, it is like our Salem Bar Association, you can file it at leisure. Supreme Court said 120 days, the provision says no person shall file a return statement beyond a period of 120 days, and court also cannot receive it thereafter. Now the tail contains sting. Now Supreme Court said this shall is shall. Now you have all this in your mind. In BNSS there are so many shalls. Shall is shall. Madam is very strict. Shall is shall. You can take refuge under 166 IPC if you want to say that a stakeholder is failing in his duty. And for you also, so many time limits are fixed. For taking cognizance, for framing charge, to dispose the trial, to send the bundle to the committal court, for pronouncing judgments also 30 days and 45 days. If you also doesn't oblige with the time frame, High Court will say whether it is shall or may. Okay? Justice is justice for all. Right? Yes, we will come to 174. What are the fancy things, new things introduced? One is concept of zero FIR. Should I explain zero FIR, or you are all aware of that? See, a cognizable offence, if it is reported to the jurisdictional police station, they will assign number. If a cognizable offence is given to a non-jurisdictional police station, he will not give a number. He will assign 0 and send it to, yes. One famous important judgment is our Jaggi Vasudev's judgment. You know that? Do not know. Jaggi Vasudev, his number, his case. A case was given by his father-in-law in Karnataka, stating that Jaggi Vasudev's wife died in a mysterious this thing in Coimbatore. Now, why I am telling this as an example is, father-in-law is in Karnataka. He lodges an FIR in Karnataka, stating that his daughter died in a suspicious circumstances in Coimbatore. This was registered as a zero FIR in Karnataka, sent to Tamil Nadu. Understand this? Yes. Now, previously, the word irrespective of the jurisdiction doesn't find place in 154. Now, in 173, the word irrespective of area, underline that, that gives the power to register zero FIR. Okay, irrespective, 173, third line, second line, irrespective, that is 0. You can read one judgment in Neelu Srivatsava versus state represented, state by NCT Delhi, 2021 Delhi High Court. State Neelu Srivatsava versus state NCT Delhi, 2021 Delhi High Court judgment, which will give you a clear picture as to the history of zero FIR, how it came, which law commission recommended. If you want to know about anything, you can read that. Another is, if a zero FIR is sent to a non-jurisdictional magistrate, how it has to be handled, right? It is in the case of state of AP versus Punnatti Ramulu. Then you have all written, you all have written. Satyander Kaur versus NCT State, NCT Delhi, and State of AP versus Punnatti Ramulu. Zero FIR, if it is sent to the other jurisdiction, what is the duties and intricacies in that? Okay. Then 173 subsection 1 Roman 2. 173 subsection 1 Roman 2. Now, from 1st July 2023, an informant or a victim need not go to police station for lodging a paper FIR. An electronic FIR can be registered from 1st July 2024. Okay. Second important questions to magistrates. I do not know how magistrates are going to sleep from 1st July 2024. No, I am seriously telling. See, now the woman or a man is going to type something and throw it to the police station. Finished. Within 1 second, that man will forward it to you. Hereafter, nobody will come and tap your doors. Now, what that fellow will write in the GD, FIR received by 12 o'clock, 12:01, sent to magistrate by 12:02. Our magistrate may open it by 12:03 or next day afternoon 12:03. What is the time of receipt in the court now? Your opening time is not receipt time. See, please understand this. Please understand this. Your time is opening time. He will nicely write, I have sent. The moment he sends it, it is sent time. That's all. You cannot say, I opened it only by this time. The moment it is thrown into your system, it is received time. You will open it after 1 year also. So, I do not know how are you going to handle this situation. He need not bring it to you at all. Electronic things, sir. Just one tack, that's all. Gee, every day morning if you check also, what will you write in that? Or what you will record? It is all, if it is an express FIR, you are expected to put the time of receipt. Opening time is not receiving time. This is what I want to impress upon you. He can send at any time, no. See, a magistrate is a magistrate 24 hours. If he has 25 stations, received, what madam is telling is right. You cannot write that I opened it at this time. I received, that's all. So your electronic gadgets has to be 24/7, and your wives will have a hectic time with you. Previously itself they will be asking, what are you doing always in the phone? Now it is indefinite. Some rules should come for all this, because they are also human beings, right? Yes, ji. Ji, can you expect a magistrate to get up every 1 hour and see? Yes, so that is the time they send, that's all. So if one harassment is not there, that he comes at any odd time and taps at the door. Yes. Sir? That is there. But FIRs, no. He will say I have sent it. Okay, so that is one thing. Then electronic FIRs, see, I will tell you like this. I do not know whether you welcome this zero FIR or not. We will imagine zero FIRs are really a very good measure in one sense. We will imagine a situation where there is a communal riot in certain particular place, or the assailant is a very strong fellow. That assailant, after beating you also, he will know that he will only come to this police station. He may also prevent you to coming from that police station. In those courts, the victim may escape and go to some other police station and say this reason as a reason and register an FIR. So see, everything has got a good and bad things. Imagine a village which is a very furious place where two people are fighting seriously, and the party who is a victim may not be permitted for a very long time to enter into the village itself. In those courts previously there is no other option. Now it is a good thing, right? And electronic FIR registration, signatures, the victim or the informant has got a time for 3 days. He can go and sign 3 days. My humble thought is, when you accept the evidence by electronic way, no, he can also sign an electronic form and send. This is some other thing which may also be attended by subsequent rules also. Digital signature, right? Then, if you want to understand, I told you about preliminary inquiry, no? Such a preliminary inquiry is now provided in 173 subsection 3. Previously, what Lalita Kumari said, it categorized 5 categories, 2M and 3C for preliminary inquiry. Now, 173 subsection 3 speaks of preliminary inquiry. If you want to understand what is preliminary inquiry, you read Sirajuddin versus State of Madras. What is preliminary inquiry? Sirajuddin versus State of Madras, 1970, State of Gujarat versus Shyamlal Mohanlal Choksi, 1965. Sirajuddin versus State of Madras, then Shyamlal Mohanlal Choksi. State of Gujarat versus Shyamlal Mohanlal Choksi. It is 1965 judgment. Right? Okay, whether FIRs will be still uploaded? Yes, FIRs should be uploaded within 24 hours as was laid down in Youth Bar Association of India versus Union of India. Youth Bar Association of India versus Union of India. 2016 Supreme Court. Youth Bar Association of India versus Union of India, 2016 Supreme Court. All the FIRs should be uploaded by the police in their websites within 24 hours. Exceptions are women-related offences, offences relating to national security, and POCSO-related FIRs will not be uploaded. Okay. Next question is, now we are going electronically, whether charge sheet should be uploaded in the police website as a public document. Answer is no. Saurav Das versus Union of India. Saurav Das, RAV versus Union of India, 2023 judgment. 2023 Supreme Court says, charge sheets are not public documents. It should not be filed, it should not be uploaded in the websites, and copy applications by third parties also should not be entertained. Right? In this context, also read another one judgment, Miss A versus State of UP. Miss A, capital A, within inverted commas. Miss A versus State of UP, 2019 Supreme Court. This says, please listen, Miss A versus State of UP 2019 says, even after the charge sheet is filed in the court, accused is not entitled for copy. I am repeating, we always believe once police files a charge sheet and taken on file, you can get a copy by applying copy application. Miss A versus State of UP, Honorable Supreme Court says that accused will get copies only in the stage of 207. Okay, you understand? Accused gets the copy of the police report not after the police files in the court, only after service of summons on him and only on the stage of 207. 207 is now 230. One improvement in 230 BNSS is free copies should be given not only to the accused but also to the informant or victim. You should give, court should give. Free copies should be given not to the accused alone. On the day if she is present, it should be given, or if she is with the advocate under 18 subsection 8, advocate should be given. Which advocate? Victim's advocate. Why? Victimology. BNSS speaks of Bharatiya Nagarik Suraksha Sanhita, that is People Protection Code. Just imagine Chandru was beaten by somebody. Chandru goes to the police station in the year 2010, lodges an FIR. After lodging FIR, Chandru do not know what has happened up to Supreme Court. BNSS says in every stage inform the victim. Right? Victim should be given, and in registration of FIR also, 173 also, 173 subsection 2 says copies of the FIR should be given to the informant / victim. That is, if Chandru is assaulted, my neighbor would have been the informant. Only my neighbor knows what is the case that he has given. Honorable judges, you understand the plight of the victim. One fellow will go something to his knowledge, he will file an FIR. But real victim will not have the copy of what is being given. And you just see this 230 and all is a welcome move. You give a bulk of paper to the accused and says these are all the things which are relying. Victim should know what is the investigation. One man is investigating something. See, we all have kept shamelessly from 1861 till 2023 just to see the plight of a victim. Where is the procedure for victim to participate? Where is the procedure for victim to oppose the bail? Free copies, you give volumes to this man. Morning itself I said, this is a man who has intruded into the privacy of somebody. He wants to protect his right to life and personal liberty. That was a person who has already lost his life right to personal liberty. Right? Now free copies should be given to the victim during the stage of 230, that is free copies. 232 says committal proceedings should be finished by the magistrate within 90 days, extendable to 180 days. And any application filed by any person, either the victim or the accused, in a case exclusively tried by the sessions, committal magistrate should not have any business in all these applications. I am repeating, if a proceeding is a committal proceedings, magistrate shall forthwith give the free copies. The word used is because committal proceedings are pending for so long a year. Now whatever it is, committal proceedings, magistrate shall forthwith give the papers, and commit it within a period of 90 days, extendable to 120 or 180 days, and any application filed by either of the side to make any dilatory tactics, magistrate is not worried about on that, should put it to the main bundle and send it to the sessions court. This is 232, 230, and Miss A versus State of UP also I have told you should not give copies on the request of the accused prior to 207 stage. Okay. Then coming back to section 173 subsection 3. 173 subsection 3 says police persons can make a preliminary inquiry for offences which are punishable more than 3 and less than 7 with the permission of the Deputy Superintendent of Police. One thing you should note that this is a deviation from Lalita Kumari. Lalita Kumari categorized 5 categories. Now BNSS says 173 subsection 3 says it is for offences which is punishable more than 3 and less than 7 years, right. 173 subsection 3 subsection 1 says so. In the morning I told you, investigation is not the domain of the police alone. 173 subsection 3 Roman 2, what does it say? Proceed with investigation when there exists a prima facie case. Suppose if the police person is pretending I have to do a preliminary inquiry that it doesn't reveal a prima facie case. If a person approaches you under 175, now it is 175, previously it is 156.3. 175.3, you can, after reading the information, if you feel that the offense makes a prima facie case, the complaint makes a prima facie case, you can ask him to investigate in spite of the bar under 173 subsection 3. Okay. Then subsection 4. What is subsection 4? This is equivalent to 154 subsection 3. What was 154 subsection 3? If a police person, station house officer, refuses to register an FIR, then the content should be sent in a registered force with AD. Through that AD card, even in spite of the fact that if the SP of police is reluctant, then you can approach the magistrate under 156 subsection 3 of CRPC. This was the older law, right. Now 173 subsection 4 says any person aggrieved by a refusal on the part of the officer in charge of a police station to record the information referred to in subsection 1 may send the substance of such information in writing and by post to the Superintendent of Police, who, if satisfied that such information discloses commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by any police officer subordinate to him. Previously, he will ask the SHO to do. Now, two things. Either he can do or he can depute any other officer, because see, she is the station house officer. She is reluctant in registering my case. I go to SP. SP says you go once again to her. What will be the mood of her? She will be very angry with me. What she will say? Oh, you went there. Finally, came back. Now this is also a welcome move. Now the SP can say, no, no, you go to this fellow. And in this provision itself, they have said that you can go to the magistrate. See what it says? And such officer shall have all power of an officer in charge of the police station in relation to that offence, failing which the aggrieved person may make an application to the magistrate. Here itself they are telling that if you are aggrieved by all this, you can go to the magistrate. One judgment is Sakri Vasu versus State of UP. Sakri Vasu, S-A-K-I-R-I-V-A-S-U, Sakri Vasu versus State of UP, 2007 Supreme Court. Sakri Vasu speaks of fair investigation, proper investigation, then speedy investigation, further investigation. Okay. I will ask you one question. Previously there was one section called as 173 subsection 2. Now this is 193. What is 173 subsection 2? 173 subsection 2. Charge sheet, police report, final report, challan. You can call it as anything. Charge sheet, police report, final report, then challan. This was 173 subsection 2. What is 173 subsection 8? Additional or further? Okay. Should the police get the power from the court or prayer? Should the police make a prayer or permission from the court for further investigation? You read 173.8, it will not say like that. 173 subsection 8 will give the power of the police for further investigation. That's all. He can do that up to judgment. He need not take permission from you. This was laid down in 173 subsection 8. One important judgment you all should read is Vinubai Haribai Malavya versus State of Gujarat. Vinubai Haribai Malavya versus State of Gujarat. 2019 Supreme Court. Vinubai Haribai Malavya versus State of Gujarat, 2019 Supreme Court. Okay. What was said in that Vinubai Haribai Malavya versus State of Gujarat? Two things, important things. Vinubai Haribai Malavya overruled a judgment of this. Vinubai Haribai Malavya is a full bench, 3 judges. It overruled a full bench judgment. Okay, which is a very strange thing, will not happen like that. Why it has overruled is, morning we read section 2H. We all morning discuss section 2H of CRPC. What is 2H? Investigation. 2H investigation, CRPC 2H was investigation, right? Now it is 21L. Before this Vinubai Haribai Malavya, it was believed that further investigation cannot be ordered by the courts after charge sheet is filed, right? Before Vinubai Haribai Malavya, it was believed that further investigation under 173.8 cannot be made by courts after filing of charge sheet, because a famous judgment was Devarapalli Lakshmi Narayana versus Narayana Reddy. Devarapalli Lakshmi Narayana versus Narayana Reddy. 1976 Supreme Court full bench. Devarapalli Lakshmi Narayana versus Narayana Reddy. 1976. This judgment held that police can file a charge sheet and can make further investigation when and whenever it pleases them. However, this judgment has also said court has no power for ordering for further investigation after charge sheet is filed. This judgment was held to be a good judgment from 76, 86, 96, 2006, 2016 for 43 years. 43rd year, Honorable Justice Nariman, Rohindra Nariman said, this judgment is per incurium because it is not valid in eyes of law, because those 3 judges have not understood what section 2H is. 2H is, investigation is not by police alone, it can be by any person, by magistrate. So a magistrate also has a power. When police can have a power under 173(2), magistrate can also. See how beautifully it was read. Just seeing one provision, 3 judges said that is a per incurium judgment. They do not understand what is investigation. They were understanding investigation as the domain of police. So Vinubai Haribai Malavya said, further investigation can be done by the court after charge sheet is filed until the commencement of trial. Please jot it down. Further investigation can be ordered by the courts or magistrates after charge sheet is filed until the stage of trial. This was laid down in Vinubai Haribai's Malavya, right? Now next question. When do a trial commence? Because Vinubai says you can order for further investigation only up to the until commencement of trial. It is court's power. Police can still ask for further investigation at any time. This is one thing. Now my question is, Vinubai says court can order for further investigation until the commencement of trial. My question is, when does the trial commence? Excellent. Yes. Yes. Hardeep Singh versus State of Punjab, 5 judges constitutional bench says, Hardeep Singh versus State of Punjab, 5 judges constitutional bench 2014. Hardeep Singh versus State of Punjab, 5 judges constitutional bench says, commencement of trial is after framing of charges. Okay. A trial gets commenced after framing of charges. So, framing of charges, after the framing of charges, court cannot order for further investigation. This is one thing. Next question in Vinubai Haribai Malavya is, should the police obtain permission from the court for further investigation? Old court was silent in that. However, Vinubai Haribai Malavya says police should obtain permission from the court for further investigation, especially when a trial has got commenced. Because trial judge moves in certain direction. He has got some report. This person, our person, no, he will do further investigation. He will go in the, yes, court will be going from Bangalore to Chikmagalur, right? Then our policeman will go from Bangalore to Chennai. Now the court said, Vinubai Haribai Malavya, the Honorable Court said, police, even though there is no mandate in CRPC under 138.8 for the police to get the permission of the court, using the doctrine of contemporaneous expositio, that is contemporary position. Supreme Court said, invoking the doctrine of contemporaneous expositio, police should get permission for further investigation. That means, Supreme Court said, in this country, under 173.8, policemen are in the habit of taking permission. And Supreme Court has recognized this as a good habit. So, we are telling that the police in this country, for any case which is pending trial and trial is going on one direction, if you want to have a further investigation, you come and tell us. We will say whether it is wanting or not. See, I am telling, even the Parliament or the Supreme Court has got greatest faith in the system, judicial system, over and above the police. Right? This is what was the law laid down there. Now, because I have started with one thing, what is commencement of trial, I will also tell you what is termination of trial. Right? Anybody can help me in reading 353 of CRPC, not BNSS. You have 353 CRPC with you? 353 CRPC. Please read. You have abandoned the old CRPC now itself. Gee, it was with us from 1860, gee. Section 353 CRPC. Please read. Read, brother. Anybody can read? Ji. I want you to read that. (353) CRPC. Read. Anybody read? We are wasting time. Yes, ji.
The judgment in every trial in
Section 353 CRPC.
The judgment in every trial.
Please listen and also stop. The judgment in every trial.
In any criminal court of original jurisdiction. shall be pronounced in open court
shall be pronounced in open court.
by the presiding officer immediately after the termination of trial.
One second. Judgment shall be pronounced immediately after the termination of trial. Now all learned judges tell me, what is termination of trial? Or when does a trial get terminated? Huh? When the prosecution rests its case, then? After arguments. Okay, any other better answer?
Evidence is finished.
Brother, please read once again, brother. I will give you a chocolate.
The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of the trial.
Judgment shall be pronounced by the presiding officer immediately after the termination of trial. My brother says, after termination of trial, you pronounce the judgment. But madam says a different answer, which I want to say in the mic. Please, madam.
Till pronouncement of judgment.
Excellent, madam. Madam says, trial gets concluded after the pronouncement of the judgment. Right? Excellent, madam. Madam, I will give you a dairy milk, madam, today evening. You purchase and give, I will give it to you. See, reading the first principles of law, it gives us an idea that judgment is different from termination of trial, or judgment is something different. It happens after termination of trial. Why I am insisting this now is, Arjun Pandit Rao Kotkar is a very important case which will have more significance from 1st July 2023. Why? Yes. We all have become electronic. Right? Arjun Pandit Rao Kotkar says, you can receive court can receive 65B certificate until trial is not over. The word used is, court can receive 65B certificates until the time trial is not over. The word used is verbatim, trial is not over. I am not substituting any other word. Arjun Pandit Rao Kotkar says, court can receive 65B certificates until the trial is not yet over, which simply means that till the termination of the trial in one angle, right? Now, Abdul Yaqub Memon versus State of Maharashtra. Abdul Yaqub Memon, M-E-M-O-N, Memon versus State of Maharashtra. Beneath that, right, Sukhpal Singh Keira versus State of Punjab. Sukhpal Singh Keira, S-U-K-H-P-A-L, Sukhpal Singh Keira, K-H-A-I-R-A, Keira versus State of Punjab, 2020 Constitutional Bench. 5 judges of the Supreme Court. 5 judges says, I will tell you, see, please listen, you can have the, you can be relaxed, put the pen and all. First, they have said when trial comes to a conclusion. Point 1, 5 judges bench says, a civil trial concludes when? Sir is telling closure of evidence. Any other better answer? Madam has said one beautiful answer. I have reserved a chocolate for her. What did she say? Sukhpal Singh Keira says, 5 judges Supreme Court says, a civil court's trial gets concluded on the pronouncement of dash. Okay, I will ask you another one thing. Civil judgment contains 2 parts. How many of you practiced in civil side as a lawyer? Okay. How many of you have been to copy application sections for getting a civil judgment? Whether the judgment and decree will be ready on the same date. One man sitting as a decree clerk, what he will say? You should give the mic to sir. Sir is telling the right. Sir, tell the answer frankly, sir. Decree is not yet ready. You say, sir, as you said. Decree?
டிக்ரி நாட் எட் ரெடி.
தமிழ்ல மலையா இங்கிலீஷ்ல ஏதோ சொன்னீங்க, கர்நாடகால சொன்னீங்க.
டிக்ரி இன்னும் ரெடி இல்லை சார்.
Decree இன்னும் ரெடி இல்ல. Okay. Now you are thinking that judgment and decree is given by you. Right? Anji.
ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಬಂದಿಲ್ಲ.
See, I also is a victim of that. You apply copy applications, sir, judgment ready, sir, decree clerk type அடிக்கல. Decree clerk decree type அடிக்கல. அது ஒரு அரை பக்கம் தான், 4 லைன். மேல decree, take the last portion of the judgment and put it. This gentleman will not do for months together. Right? You cannot file EP. But the other man, no, judgment debtor, he will get that, he will go to the appellate court. Right? Now Supreme Court says a civil trial gets concluded on the date of pronouncement of judgment, not decree. Supreme Court further says decree is not coming out of mind of the judge because he has already drawn a judgment. It has to be taken on the administrative side and put it in a paper. So a trial starts, it concludes till judicial mind of the judges applied in that particular case. I am repeating, trial will only end when the judicial mind of the judge stops in that particular case. So in a civil case, a trial gets concluded on the date of judgment. Coming to criminal case, trial gets terminated on the date of acquittal of accused. Now I am dealing with acquittal judgments. Criminal case, trial gets concluded on the date of acquittal. Coming to conviction. In a criminal case, trial gets terminated not on the pronouncement of conviction, sentence. See how beautifully they have said, because sentencing requires, yes, this is Sukhpal Singh. So 353 was interpreted differently. Now come to Arjun Pandit Rao Kotkar. 3 judges says 65B certificate need not be filed on the date of filing of the copies. Even if it is missed at the time of trial also, court can very well receive it provided he says sufficient reason why he has not filed until the commencement of, until the trial is over. So please read that. And in Arjun Pandit Rao Kotkar, please take a copy. There are 2 parts. Okay, one is the judgment of Honorable Justice Rohinton Nariman. Another is the judgment of Honorable Justice V. Ramasubramaniam. You take both the judgments, read that, you will understand all the nitty-gritties of full electronic evidence. And don't get deceived by the other judgments, because all the judgments of Anwar, and all, everything was discussed in Arjun Pandit Rao. And it has also said under what circumstances 65B cannot be obtained or need not be obtained. Suppose the other side is not, the other side is having that. What the man will do, plaintiff will do, he will just say he is having that. Then he will issue process. Court can also use 165, court can use section 91 under CRPC also, 311 also. So the Arjun Pandit Rao Kotkar has elucidated beautifully what are the process of securing electronic evidence from the other side, and a man who is important of producing something cannot be compelled, need not be compelled. Right? This is also there. Then in Arjun Pandit Rao Kotkar, because today morning we saw section 2 subsection 1A. What is that? Audio video and this thing. In that it said state should make rules. Now Supreme Court Arjun Pandit Rao says, if you want to know more on electronic evidence, it has said on one thing, that is November 2018, a Chief Justice's conference was made and a meeting was made and a draft electronic, how to deal with electronic records. A draft paper was presented. That paper was presented by my Lord's Honorable Justice Rajesh Bindal. He was the committee of that electronic, chairman of the electronic committee. So take down that paper also. It has given all the procedures as to how to store electronic evidence, how to transmit, how to retain, how to use. Okay. Next question is, how you will give a copy of electronic record to another man. See, now that everything is becoming electronic. One case, you will all be knowing that it is Gopalakrishnan alias Dilip versus State of Kerala. Okay, I think public prosecutors will be aware of that. Prosecution case is that a woman went with a story that this particular man, Dilip, has photographed me, has assaulted me, and all these sexual contents are in the pen drive. And she gives a complaint, stating that he has taken obscene all this and thing. Case came to the stage of filing of 207, furnishing free copies, right? This man, accused, is telling, give me all the contents. She has filed a pen drive. Now the pen drive contains obscene materials touching the privacy of a woman. You understand? But that lady is telling, these are all things that he has made on me. But this man should know what it is. It is filed in the court by the prosecution as a pen drive. This man files an application under 207 stating that give the pen drive to me. Court takes a stand that pen drive is not a document, it is a material object. It will be marked only as MO. Accused says it is a document. Both of them go up to the Supreme Court. Supreme Court said what both are telling is right. Frame is the pen drive, content is the document. I told you in the morning, judges are plain and wise people. See, for this you need not read any law. Prosecution is telling that frame as a pen drive, yes. This man is telling that without knowing the content inside the frame, I cannot conduct the case. This is also yes. Then Supreme Court said, what prosecution telling, what both of you are telling is right. And why I am insisting on Gopalakrishnan is, they have stated, they have held so many strategies as to how a copy of electronic document has to be given to the other side. See, now I am telling, a woman is complaining on Chandru, that Chandru has made all of me obscene, Chandru has made me naked and doing this, blah, 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 blah and all. Now Chandru is taking a stand that she has given only cut copies, right? She has initiated all that and she is a party to that. Document which she files before the court of law will be a altered copy. Now, what is the nature of copy that prosecution or the court should give to the accused? Supreme Court in Dilipan says, you cannot give a copy, you should give a cloned copy. C-L-O-N-E-D. What is the difference between copy and cloned copy? I told you, you should explain to me like you should explain to a villager. Gee, tell me, see, you should explain like you should explain to a villager. What is cloned copy means? The original document would have underwent alterations, additions, modifications, right? Tamperings, or it would be like an immaculate woman, nothing. Morphed. Whatever is inside, including the message of altering, additions, you give the cloned copy, it is just original, that's all. It is not taking a printout and giving. If you take out a printout from an electronic this thing, you are cheating the other person. So cloned copy is replica what is inside. It will reflect everything. If you add, if you subtract, if you do something, everything, so the accused will now impress upon the court, see, this is a document where there are a lot of additions, modifications, alterations, so she has not come to the court with a clean hand. She is projecting a favorable document on her side. So, Dilipan's case has already said, Gopalakrishnan as Dilipan has already told you the guidelines of furnishing an electronic copy to the other side. Suppose this woman is telling that my nude photo is there. Accused wants it. Can that be given? What is the privacy of the woman? Now Supreme Court in Dilipan itself says, Dilip's case, if a document which the court feels should not be given and it is in the court, the advocate, the party concerned and an expert should sit on that in the court and peruse it. Why expert? Yes, we were talking about that only. No, expert will now see whether it is tampered or not. And accused, if he sees that, he will say, sir, I am not at all that man in that, sir.
Sir, sometimes what happens is the police officer sees that material, sent it to FSR for examination. That will be sealed by the FSR. Now, if I open, then that if the court opens, then again it will become like without not in the stage of trial you open. Because this 207 is given at early stage.
See, 207, court, see, either the court should give it at the 207 stage.
No, you see, the court has no business in this because we are neutral parties. The police have seized it, sent it to FSL. The FSL, the original is with the
Yes, it will be with them.
with them. Now a copy has to be given to accused.
Yes.
Now who has to give the copy?
All free copies, as per the new CRPC, police should make copies. Yes.
What is the role of court? Why should
Suppose if some documents which the police says or if the complainant says my modesty is involved, it should not be given. Obscene things, contents.
that is the allegation?
You should not give. In that case, the police will not give. Or
His right is different.
that is the reason I said in Gopalakrishnan, for that only, they are telling that 3 people can come and see in the presence of the court. So you should open a docket and say, as per the directions of Dilipan alias Gopalakrishnan, the case is like that, I am permitting them to see. Or else how can he conduct the trial? He will see that would be amounting to violation of natural justice. So tell me, sir, whatever is the doubt, tell me.
No, because at that stage, court cannot intervene, see everything and then tell, okay, a copy has to be given. It is between the...
At which stage? See,
At the stage of
I have
forwarding.
understood what the honorable judge is telling. Please listen, 1 second. Free copies are given under section 230.
Pre-trial stage.
Yes, pre-trial stage. Yes. Then, what judge is telling is, I am not aware of the document. Now, policeman who is always instructed right from the FIR that if the FIR also contains any obscenity in that, you should not give the copy of FIR even to the informant. Or you should give the copy after redacting. Right? Even a charge sheet, if it contains like that, courts are mandated to redact and give. Now, presumably, there is a document which is a matter of controversy. That document is in an electronic form in a pen drive, right? Or in a CD. This document copy, contents of that has to be shown to the accused.
Given to, not shown.
Obscene should not be given. The mandate,
But he needs to get it analyzed from his lawyer or...
he can send it from court. He cannot have it. No. See, victims, see, honorable judge, there are 2 things, balancing the right of the accused and protecting the victim. When that, see, one woman goes and says, Chandru has stripped me, and this is the photo. Chandru cannot ask the photo once again back. Chandru can ask the court that the photos or the contents which the prosecution has given it to the court can be sent to an anthropologist or a forensic scientist thing, and anthropologist will say, is the photo resembles Chandru's photo, is the photo resembles...
They will not give. That is the problem. FSL will only say...
In Tamil Nadu, in High Court, thousands of cases we have seen where if suppose I am implicated in something, I will tell you, we will go a bit detail after some 5 minutes also. See, there are 2 things. Now, 1920, this is not required. See, there are 2 things. One is, there is one act called as Identification of Prisoner Act. 1920. What does that act say? That act says, police and the prosecution can have photographs, footprint, fingerprint of the accused. This was the act of 1920. Act called as Identification of Prisoner Act 1920. This act was once again in 2022 was amended as Criminal Law Amendment Identification of Prisoner Act. Once again it says you can take photos, footprint, fingerprint and blood samples. Then coming down to Evidence Act, section 73, court can compare signatures, right? 311 is another provision enabling the court to call details from the accused, right? Now, one judgment of the Honorable Supreme Court in State of Bombay versus Katti Kallu Ogad, 1961, 11 judges of the Supreme Court, State of Bombay versus Katti Kallu Ogad, right? The question is whether incriminating substances can be taken by the accused, or can accused be compelled to reveal incriminating circumstances. Supreme Court said Article 20 subsection 3 of the Constitution speaks of, what Article 20 subsection 3 says? No person shall be compelled to be a witness as against himself, right? Amma? No person, it is doctrine of self-incrimination. Yes, doctrine of self-incrimination. To what extent that doctrine of self-incrimination will help you? Supreme Court in 2019 in Sonveer alias Somveer versus NCT Delhi, please read that judgment. PPs you can read that. Sonveer alias Somveer, S-O-N-V-I-R alias Somveer, S-O-M-V-I-R versus NCT Delhi, 2019. Supreme Court said in India, accused don't enjoy the right of Mirandaism. What is Mirandaism? Miranda. Cool drinks. Miranda versus State of Arizona is a famous judgment. Miranda versus State of Arizona is a famous judgment of United States where the accused has got a right of silence from the time of police examination. See, police will call a person that I am suspecting you as an accused. You need not answer anything to me. You can maintain right of silence. So they believe too much in their investigatory skills. Supreme Court said in Sonveer alias Somveer, such right of Miranda, such Miranda right is not available in India because section 160, 161, 162 read together of CRPC, what does it say? Police can summon any person acquainted with the fact of the case and that person shall truly speak of everything. So in India, accused do not have a right of maintaining silence with the police. However, 164, if the accused is taken to the magistrate, magistrate will tell him the right. What he will say? You do not have any duty to confess. And if you confess, yes. Now, policeman vis-a-vis Article 20 subsection 3 vis-a-vis doctrine of self-incrimination, Chandru is arrested for an offense of rape, right? Chandru need not say, I will not give my sperm. You cannot take my blood. I will not cooperate. I will not speak out. Now, whatever test, no, but for incriminating testimonials, police can compel anything from me and take. In this Identification of Prisoner Act, it says by making necessary force. That is, if I don't react to, if I don't pose to the photo, they will give one slap and say this is necessary force, pose. And there is a famous saint who was sometimes in Tamil Nadu and sometimes in Karnataka, right? He said, I don't have a sperm. And our investigating agency were still begging with that fellow. You know, court says, medical science says, see, our police, they should read things more. A man has raped a woman, and in that woman's dress, spermatozoa of this man is there. Now what police does, they arrest that fellow and beg him for some sperms. That fellow is non-cooperative. What is the best sperm in the human body? Blood. Any material that the sperm contains, that DNA material is in the blood also. You cannot say that I will not give a blood. Necessary force can be used for drawing blood samples, right? Now, only one thing was absent in India. What is voice test? No law has given anything on that. But for that, there is law for everything, handwriting, blood samples, all this. So in Ritesh Sinha versus State of UP 2019, Ritesh Sinha, Ritesh, R-I-T-E-S-H, Ritesh. Ritesh Sinha versus State of UP 2019, Supreme Court said, Sinha, Supreme Court in 2019 said, there is no law in this country for voice test. UP 2019, Ritesh Sinha, Honorable Supreme Court said, there is no law in this country for voice test. We use Article 142 Bake rules unless and until law is made. Now law is made in BNSS section 346. So one thing is, my photos can be taken and it can be sent to forensic experts. Suppose I am firing a man, right? I had a case. I intended to conduct it in Parni, a place in Dundukal. One old man, because of the quarrel with the next house fellow, he was practicing firing in his own house. He is 76 years old. I will send that video also today. You all enjoy that video. The precise firing. Even our policeman cannot do. That fellow came, he placed one hand over his another hand, tuck, tuck, he shot, two fellows fell down. Neighbors, for no reason, just some small boundary dispute. Right? He fired two people. Now Tamil Nadu police, what they did, this man was firing, the video was not very clear. This man arrested him, took him there, photographed him, and took the CDR also, sent both to Tamil Nadu Forensic Science Laboratory with a query to Anthropology Department, whether this man in the photo corresponds to that man in the video. Answer is yes. And the old man engaged me some 6 months back. Now he is with his maker. He died. So Chandru is very fortunate. Okay, we will meet tomorrow then. Bye bye. Thank you so much.
Hello. Thank you, sir, for giving us a detailed insight and enlightening on the new BNSS. We will resume tomorrow at 9:30 a.m. to hear continued lecture of Mr. E.V. Chandru, sir, on other provisions of BNSS. With this, we conclude for the day. IT is arranged in first and third floor. Kindly.